Good morning, everybody. Since this is the last show of this week, happy Super Thursday. Welcome to TCF Live. My name is Dan Soul. I will guide you on this 3-hour journey through Courtlandia, starting with Magistrate Urich.
There you go.
Good morning, Your Honor. This is Kamal.
All right. And you're Mr. Hussein?
Yes, sir.
Very well. Mr. Hussein, you were present earlier when the court explained the informal hearing process. True?
Yes.
So you understood the court's instruction that you must select from one of three options to protect your rights, yes?
Yes, sir.
Okay. Thank you very much. Please listen carefully. The citation before the court indicates that on May 23rd this year at 1:06 in the morning, you were operating a 2016 Toyota, white in color on 11 Mile Road, near Cass, in the city of Berkeley. Now, this is an important distinction. So, at that time, you were cited for impeding traffic, which is a 0-point non-recordable violation. However, what Officer Smith states he witnessed that morning was a margin of speeding of 10 miles per hour over the speed limit. So rather than writing that for a more severe violation of speeding 1 to 10 over in that area, he wrote this for impeding traffic instead. But regardless, Mr. Hussein, today's your day in court. So as to the impeding traffic, you may admit responsibility, you can admit and explain, or you may deny responsibility, and the court will swear the parties and conduct your trial forthwith. What do you want the court to do for you?
Your Honor, the right share is my main arm of source. I totally respect the officers' decisions. In future, I am more focused, and I will learn from this experience, Your Honor, and your kindness, Your Honor. I totally, lost my job like last 6 months. I am very hard to, survive my all skills and everything, Your Honor.
Okay. So are you wishing to confirm that on that date you did in some way impede traffic? Is that correct?
Yeah.
Yes?
Yes. Yes.
Okay, thank you. The court accepts your plea. And I think the court heard you say that you're very remorseful and you're also suffering under some economic challenges. Is that right?
Yes, sir.
Very well. Officer Smith, anything you want to share before the court imposes its sanction?
No, Magistrate.
Very well. What the court's going to do for you, Mr. Hussein, is the fine for this is $175. That is payable through the pay portal on the court's website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. The court's going to mark that due way out, so 28 days. And if that date comes up, Mr. Hussein, and you don't have the ability to pay that in full, please call the court. Don't let it go stale. Just make sure you either pay it or phone the court before the 28th. Okay?
Okay.
Good luck to you.
Thank you. Thank you for your time and consideration, sir.
Thank the officer.
Thank you.
Thank you. Okay. So that was him. That was him. Yeah. Calling case number 26, P like Berkeley E 02656. This is People versus Mohammed Ali Owadi. Mr. Owadi, are you available?
Yes, Your Honor.
All right, thank you. Mr. Owadi, you were present earlier when the court explained the nature of an informal hearing. True?
Yes.
So you understood the court's instruction that you must select from one of three options to protect your rights, yes?
Yes, Your Honor.
Mr. Owadi, the citation before the court was issued on May 25th of this year at 1:45 in the morning. You were operating a 2025 Ram, black in color on 11 Mile Road, near Cass, in the city of Berkeley. And at that place and time, you were cited for exceeding the posted speed of 30 by a minimum of 11 to a maximum of 15 miles over. Officer Smith's remark, which shows on your ticket, indicates moving radar, solid tone, 50 and a 30. So a margin of speed of 20 miles over. What he wrote this for, Mr. Owadi, was 11 miles over. Regardless, today's your day in court. You may admit responsibility. You can admit and explain, or you can deny responsibility. The court will swear the parties and take your testimony. What do you wish the court to do, sir?
I admit my responsibility, and the reasoning for that, we're used to the city and Garden or the Garden City speed limits.
Okay, slow down for a minute. So you wish to confirm that on the date in question, you were operating a motor vehicle in the city of Berkeley and exceeded the posted speed by 11 miles over, yes?
Yes.
Okay. Thank you. So you were explaining how apparently the speed limits in Garden City are different than those in Berkeley?
Yes.
Okay. What else would you like the court to know?
That's really about it. And I was just getting myself situated while I was driving, which was my mistake. My battery had just died, and I had one friend come jump my car.
Okay. Is there anything else you'd like the court to know?
I would just like to see if I could get the points off, because I do have 0 points on my record.
Okay.
Keep it that way.
Well, the court obeys the separation of powers. Since it's the 4th of July, we can talk about that for a minute. You've got three branches of government in front of you today. Officer Smith's representing the executive branch. This court can't step out of its role as the neutral umpire and do anything about the points, nor can the court invade the province of the Secretary of State. That's her business as well. But the court appreciates your remarks. Officer Smith, is there anything else you want the court to know?
No, Magistrate.
Thank you very much. The fine for this matter, Mr. Owadi, is $170. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That is due within 14 days, and that would complete your hearing today. Please drive safely, and good luck to you, sir.
Thank you, Your Honor.
And Officer Smith, I think that completes your broadcast here for today.
Thank you, Magistrate.
Have a safe one. Stay cool out there. Already on the iPhone, your name?
Mercedes West. I was
Say
trying
that
to
again slowly, please.
Mercedes West.
Mercedes.
Yes.
Okay. Do you see Mercedes West anywhere, Miss Crystal?
I do not. I'm looking her up right now.
Stand by, please.
Okie dokie.
She's got our review hearing this afternoon at 2:05 with Judge Mike.
Okay. You're in front of Judge Meineke. So different courtroom, different Zoom ID. Sorry?
It's on the 16th. She's here for a review hearing that's set for the 16th.
Right. And that's
No,
actually,
this is
excuse me.
meant-
Please stop. You're set for a review hearing on July 16th.
oh,
Okay? So you're in the wrong court and you're on the wrong day.
I'm
so-
looking at the paper. I got a paper in my hand that say today at 8:46.
That Waymel, that may be Miss Mercedes West, but the court doesn't have your file. So there's not a thing the court can do about it this morning. And you're in front of the wrong jurist.
Oh, she's got a pre-trial too.
All right.
And you have a pretrial. What does that do?
Looks like that is set for the 9th that doesn't have a time yet. That one is still set at 8 o'clock. So it was a
In front of?
Okay.
46 with Judge Meineke.
All right, and you also have a court date on July 9th with Judge Meineke.
So I'm
it
not
was
supposed to be
set
here
for
today.
7/9 and 8 o'clock on her ticket.
Okay,
And then they removed it as I scroll up and it says 7/2/26, 8:46 with Judge Meineke.
oh,
My apologies.
all right, please stand by. Ms. West, we
Yes.
finally got you sorted out. You have something to write with?
Yeah.
Thank you. Take this Zoom number down, 305
Mm-hmm.
516. You can log into that Zoom ID right now and they'll get you sorted out. That's with Judge Meineke. That's upstairs. Good luck to you.
Thank you.
All right. Sergeant, I don't believe Carl Moses has appeared, so that's going to be marked in FTA. Oh, he's disappeared. Okay. Oh, there he is. Sergeant Muller, I did not see your motorist Carl Moses, so that's going to be marked failed to appear.
Okay, thank you, Judge.
Be well.
You too.
This is case number 26, B like Berkeley E02397, People versus Ronald Martella. That's you, sir? All right, for some reason you're not coming through. Check your audio again. Can you hear the court? All right, you just need to unmute yourself. So now there's a red microphone there. You're going to want to click on that. You're still not coming through. Okay, Mr. Martella, if you can hear the court, what the court's going to direct you to do is just stand by. I'm going to remove you from the proceeding and have you log all the way back in, and we'll see if that takes care of the problem, okay?
Your Honor.
Oh, yes, Officer Bismack.
If it does ease the process, I did do some research on this citation prior to coming to court, and this is going to be a dismissal. I don't know if that matters for the relogging.
So you're suggesting you wanted to just move to dismiss? I'm sorry?
Yeah, Your Honor, I can just explain it to you quickly. I wrote a citation for blocking Alleyway downtown. The business is north of 12 Mile.
Mhm.
It turns out when I talked to the building department this morning, that alleyway there actually does have about an 8-foot section of private property prior to the alleyway starting. So Mr. Martell does live in those apartments above the business, and I believe he was marked properly in his location, even though he was a little bit towards the middle.
All right. So that sounds like a motion to dismiss then, Officer Bismack?
Yes, Your Honor.
All right. Case dismissed, Mr. Martella. Just make sure you're parking between those lines, okay? Good luck to you.
Alrighty, good morning once again, everybody. It is TCF Live on a Super Thursday, since we will not be live streaming tomorrow. Good to have you all with me. Let's do this. We'll stay in Michigan. Let's go say good morning to Judge McNally.
Your name? You got to keep your voice up nice and loud for me, okay? Say that again.
Sure. Yes.
Good morning. You're charged with violation of parental responsibility law. You have the right to a lawyer. If you want one, I will give you one. Would you like an attorney to represent you? I can't hear you.
What am I here for?
Violation of the parental responsibility law. They think that you didn't require your child, your children, to attend school at Lakeshore Virtual Schools. You have a 14-year-old, they say, 12-year-old, that's Terrence and Jaslyn, and Antoine, a 10-year-old. So they think you didn't send that child to school, those children to school. This is a 2020 case. You sure? So do you understand what I said?
Yes.
Do you want an attorney? You sure? All right, so this allegedly occurred on September 14 of 20. If you plead guilty, or if you are found guilty, it is punishable by up to $500 fines, 90 days jail, costs, or all those. Do you understand that, ma'am? Did you sign, read, and understand the advice of rights? If you plead guilty, you will be giving up all those rights, and we are not going to have a trial of any kind. Do you understand that?
Yeah.
All right. If you still wish to waive your right to a lawyer, I'm going to enter a not guilty plea, and I'm going to send you to the Gibraltar prosecutor. Is that what you want to do? And you can talk to them and see what you can work out.
What am I working on? I'm not understanding this.
Okay, well then let me give you a lawyer. How's that? Let me give you a lawyer. All right? If you don't understand, you're charged with violating the parental responsibility law. They think you didn't make your children go to school, period. So that is the charge. We have to make sure our kids go to school. If we don't, they don't get through high school, they're in poverty for the rest of their life. 100 times out of 12. So that's the charge. I'll give you a lawyer. I will enter a not guilty plea, and your lawyer will go and talk to the prosecutor. Okay? Fair enough? I can't hear you.
Yeah.
$500 personal bond. You cannot leave the state without consent or violate a law. You must appear in court as directed. You go talk to them and you're all set. Good luck. Thank you. So he'll set you up with a lawyer on that one, John.
Yeah.
Destiny Cherie Johnson, 260-648-658 ABHC. You have your lawyer here? Okay, I'm gonna have to wait for your lawyer. I'm sorry.
Judge,
if you want
can we
to-
just check
if you
in with
wanna go-
county real quick?
Yeah, who is that? Sir, what's
I
your
believe
name?
it's Batchin, but I just want to double check.
Your name, sir?
Robert Bashan?
Yeah. What is he here for? These?
I'll get him in a breakout room. He needs to speak with Mr. Shaw if he's here for a pretrial.
Good enough. Thank you. Amanda Lynn Raymond. 263-307-053. Okay. We've got an informal. Officer, are you on this?
Yes, sir, Your Honor.
Come on up here if you would, please. Ma'am, your name? Did you initially set this for informal, right?
Yes,
Did they not offer you impeding the first time?
they did at that time, but I wanted to plead my case.
Okay, your name, sir?
Officer David Jones.
Good morning. So now you want to plead to impeding, is that right? To that charge, responsible or not responsible? All right, I'll accept the plea, dismiss the speeding, 150 is your total. You are all set, you can go down the home and take care of that, okay? Good luck. Do you have any more?
No, sir.
Have a good day, thank you.
Your Honor.
Good luck, ma'am. People against, Red, Diesha, Santoya, Kenya, Red, 260-648-670, A and B.
Hey, Your Honor.
Your name?
Diesha.
You gotta tell me your whole name.
Diesha Santoya Kenya Red.
You're charged with driving on a suspended. You
Yeah.
have the right to a lawyer. Would you like an attorney?
No.
Are you aware of the fact, young lady, that you've got 7, 8, 9, 10 warrants out for your arrest?
Yeah, I actually went to court in a few of them. I have a few more I have to go to. I'm going to the 36th district next.
Why you been doing that?
Just me and Barbara in school. I was traveling back and forth to school and everything, and they called me. It's fine. I graduated, so I'm clearing it up now. I'm sorry.
So you're waiving your right to a lawyer.
Yes.
On May 24, 26, it is alleged that you did operate a motor vehicle on Fort near Cousy and Trenton with a suspended license that is a misdemeanor punishable by up to $500 in fines, 93 days jail, costs are all those 2 points. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form?
Yes.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes.
You still wish to waive your right to a lawyer?
Yes.
I'll enter a not guilty plea. I'll go out of my way. At least you showed up on this and you're not too late on this one. $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We're going to get this over to the Trenton prosecutor. You can sign in outside the conference room on that, okay?
Okay, thank you.
Good luck. And then either way, you're coming back in front of me after you talk to them. Counsel, you can approach. How are you? Good, thanks. Jennifer Nicole Watson. You can, 26W841641 R 25W838350 R. Your name, ma'am?
Jennifer Watson.
So why didn't you take care of this? Ms. Watson, listen.
I was coming in here today. I was going to go pay it right now and then admit here.
You have the money to take care of these?
So, yeah.
You owe $315 on the first case. I'm talking about the civil infraction, Ronald responsibility that they pled down. And you owe $155 on the other case. Do you have all that money?
So I'll pay the $155 today and then next week I'll come back and pay the remainder of.
You gotta come and talk to us if you don't have the money. I thought I told you that. Didn't I tell you that? Of course I did. I tell everybody that.
You did, sir.
You gotta stop doing that. You pay in full today on 25W838350R. You pay in full, Bob. On the other file, I'm talking about 26W841641R. You pay that in full by, when can you pay that? You said next week?
Yes, next week.
Can you take this, Mr. Bologna? That's yours. Thank you.
Yes, sir. I'll pay this. I'll pay that one.
Tell me what day you can pay that. Can you pay that by the 13th?
Yes.
All right. If you need more time, what are you gonna do? Well, you can come in here on or before the due date, or you can call the staff or go on Zoom. I'll give you an extension. Please don't ignore me like that, okay? Good luck. Thank you.
Tim, thank you for gifting 5 memberships. I appreciate you, sir. And you say, let's get some new people chatting. I agree. If you are new out there, say good morning to us in the chat. We're a friendly folk here and a generous folk, as Tim just pointed out.
Mr.
Mr. Mahaney, your name?
Good morning, Your Honor. Anthony Mahaney.
All right. So we have a charge here, a violation of restricted license, as I understand, and also improper pass. As I understand it, he's going to plead, I'm sorry, he's going to waive reading, stand mute.
Waive reading, Your Honor, stand mute.
And then on the misdemeanor charge, he's going to plead to allowing an unlicensed driver to drive. That's a reduction, a 0-point violation punishable by up to 500 fines, 90 days jail, costs, or all of those. Do you understand that, sir?
Yes, sir.
Then I'll dismiss the original charge of violation of restrictions on license, and also on the improper pass, as I understand it, he's going to plead responsible to the charge of impeding traffic with the understanding that the original charge of improper pass will be dismissed. Correct, Mr. Kastner? You understand that 0 points as well?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes, I do.
If you plead guilty, you'll be giving up all those rights, and we are not going to have a hearing or a trial of any kind. Do you understand that?
Yes, sir.
To the charge, allowing an unlicensed driver to drive, how do you plead?
Guilty.
To the charge of impeding traffic, responsible or not responsible?
Responsible.
Were you in control of a 2016 Chevy that was being operated on the 12th of June of 26 at 9:34 in the morning on Jefferson near Breland in Gibraltar?
Yes, sir.
And were you unlicensed or suspended at the time?
Yes, sir.
And you knew that, correct?
Yes, sir.
And are you on probation or parole?
No, sir.
Anybody in the world force you to plead guilty?
No, Your Honor.
I'll accept that plea. I'll accept the plea to impeding traffic. I'll dismiss the violation of restrictions on license as well as the improper passing. Anything, counsel?
Yes, sir. Just when Mr. Haynes had an interlock for over 5 years. Fortunately, the other day, his father used his vehicle to interlock for family emergency. He used the family car, he used the family car to go to Roseville to pick up his car so that we go to work with the interlock. So he made an unfortunate decision to drive a distance without the interlock. He's been eligible for a license for 4 or 5 years already, so.
Are you retained to help him with that?
Yes, I am.
Good. Anything you want to say, Mr. Mahaney?
Just like to thank you for your time, and I really apologize. I did not mean to cause any problems.
Thank me for my time. What do you mean?
Just thank you for seeing me today, and
Good. You're good. 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 325 or 60 days, 175 on the impeding, $500. Can you pay that now?
Yes.
You're all set. But I'll take care of that. Best of luck.
Anybody ever notice how weird Judge McNally is when people thank him or apologize for wasting his time or anything like that? He's weird with it. Good morning once again, everybody. TCF Live on a Super Thursday this week. Let's keep an eye on Judge McNally's court, but we're going to go to Lake County, Ohio. Judge O'Donnell.
Yes, Your Honor, I gave them to Mr. Gonzalez.
What are?
The originals that you got? The updated ones?
I wrote on it, so.
Oh.
All right, go ahead.
Thank you, Your Honor. We're here in the state of Ohio versus Trayvon Hopkins, case numbers 26 CR 291 and 26 CR 869.
Here, let me.
The defendant is present with counsel Carly Snavely.
Hold on a minute. Can you have her, does she have, does Maria have
Your Honor,
those?
I have additional copies. I did.
Yeah, let me have.
I did.
Give me those, Bob.
Incorrectly write the fine on one of these copies and corrected it in the version I gave to the court. So if the court doesn't mind, I'll just cross it off and initial.
Yeah, go ahead and do that.
Okay. And does Your Honor have the waiver of indictment?
No. I never had that. You can, Carly, just keep that.
Yeah.
Just keep that. All right, go ahead. Sorry about that.
Your Honor, the defendant is present with counsel Carly Snavely. We are here in cases 26 CR 869 and 26 CR 291. In case 26 CR 291, a 3-count indictment was filed on April 27, 2026. Counts 1 and 3 are unlawful sexual conduct with a minor, felonies of the 3rd degree in violation of Revised Code Section 2907.04a, and count 2 is corrupting another with drugs, a felony of the 4th degree in violation of Revised Code Section 2925.02a4a. The state has offered for the defendant to plead guilty to a lesser included offense of counts 1 and 3, being unlawful sexual conduct with a minor, a felony of the 4th degree, which would involve amending the indictment in counts 1 and 3 to state that the said Trayvon Hopkins is 4 or more years older than AA. And it is the state's understanding that the defendant will be pleading guilty to amended counts 1 and 3 and count 2. In case 26 CR 869, a 4-count information was filed on June 29, 2026. Counts 1, 2, and 3 are unlawful sexual conduct with a minor, felonies of the 3rd degree, and count 4 is corrupting another with drugs, a felony of the 4th degree. It is the state's understanding that today the defendant will be waiving his right to have the Lake County Grand Jury indict this case and will be pleading guilty by way of information, and there is no agreement as to sentencing.
All right, Ms. Snavely?
Thank you, Your Honor. That is all entirely accurate.
Okay. Mr. Hopkins, how old are you?
I just turned 26, January 17, 2000.
How far did you go through school?
All the way to college. I just lost my college thing because I've been here, so they disqualified me.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No, sir.
Have you ever been diagnosed with or treated for any mental illness?
Yes, sir.
What have you been diagnosed with?
PTSD, major deep depression, MMD, bipolar, and major deep depression, anxiety. I had got a shot in my head November 9th of 2022, and I'm on Social Security SSI.
Are you being treated for any of those conditions right now?
Yes, sir.
Who are you treating with?
With Karen and Kim over there at the jail facility, and then Adam Guards at Signature Health.
They give you any medication to take?
Yes, sir. Prazosine, C.F.R.A, because I get seizures.
When's the last time you took it?
Yesterday.
Is that for your mental health condition or your physical condition?
Mental health condition. And gabapentin and Seroquel.
When's the last time you took any of that?
Yesterday. today, this morning. I mean, well, I didn't get to get them this morning because I'm here at court, but I take them every day, sir.
Does the medication you took yesterday affect your ability to understand what's going on today?
No, sir. And I got MMD, major deep depression, so it's a lot. I have all that documented too, with urgent care, Judith Gray.
All right, in case 291, did you get a copy of that indictment?
Yes, sir.
And it's my understanding you're going to plead guilty to the lesser included offense in count 1, unlawful sexual conduct with a minor, a felony 4. Count 2, corrupting another with drugs, a felony 4, and the lesser included offense in count 3, unlawful sexual conduct with a minor, a felony 4. Is that your understanding?
Yes, sir.
And in 869, did you get a copy of that information that was filed?
Yes, sir.
It's my understanding you're pleading guilty to count 1, unlawful sexual conduct with a minor, a felony 3. Count 2, unlawful sexual conduct with a minor, a felony 3. Count 3, unlawful sexual conduct with a minor, a felony 3. And count 4, corrupting another with drugs, a felony 4. Is that your understanding?
Yes, sir.
Understand in the 869 case, you have the right to have the case presented to the Lake County Grand Jury for them to decide whether or not to indict you.
Yes, sir.
Did you discuss that right with your attorney?
Yes, sir.
And are you going to waive that right?
Yes, sir.
All right, go ahead. He can sign it.
Your Honor, the defendant, Ms. Snavely, and I have all signed the waiver of indictments.
All right, I'll accept the waiver of indictment. I'm going to go through your rights.
Yes, sir.
And it applies to both cases. Ask you if you understand the rights and ask you if you're waiving those rights, okay?
Yes, sir.
All right, so before I accept the plea, on each of these cases, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty pleas are being made freely, knowingly, and voluntarily. So I'm going to ask you questions. If you don't understand a question, stop me.
I understand.
If you want to talk to Ms. Snavely some more, let me know and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena and make them come here and testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty on both of these cases?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes, sir.
You understand by pleading guilty to these felonies, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, sir.
In case 291, the lesser included offense in count 1, unlawful sexual conduct with a minor is a felony 4. It carries a maximum prison sentence of 18 months and a maximum fine of $5,000. Do you understand that?
Yes, sir.
Count 2, corrupting another with drugs, is also a felony 4 with an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes, sir.
The lesser included offense in count 3, unlawful sexual conduct with a minor, is a felony 4, 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes, sir.
All right. Now, I could give you a consecutive sentence on this case. That means one sentence after another for the separate offenses. If I did that, then the maximum prison sentence would be 54 months and the maximum fine $15,000. Do you understand that?
Yes, sir.
In case 869, in count 1, unlawful sexual conduct with a minor is a felony 3. It carries a maximum prison term of 60 months and a maximum fine of $10,000. Do you understand that?
Yes, sir.
The same penalty applies in count 2, unlawful sexual conduct with a minor, a felony 3, 60-month maximum prison sentence, $10,000 maximum fine. Do you understand that?
Yes, sir.
And in count 3, it's also the same charge, unlawful sexual conduct with a minor, felony 3, 60-month maximum prison sentence, and a $10,000 maximum fine. Do you understand that?
Yes, sir.
And in count 4, corrupting another with drugs is a felony 4, 18-month maximum prison sentence, and a $5,000 maximum fine. Do you understand that?
Yes, sir.
If I gave you a consecutive sentence in that case, then you face a maximum prison term of 198 months, which is 16 and a half years, and a maximum fine of $35,000. Do you understand that?
Yes, sir.
Now, if I gave you a consecutive sentence on, maximum consecutive sentence on 291 and 869, you face a maximum prison term of the equivalent of 21 years and a maximum fine in the amount of $50,000. Do you understand that?
Yes, sir.
Do you have any questions about the penalties?
No, sir.
All right. Are you presently on post-release control to the parole authority?
No, sir.
Now, you're pleading guilty in both cases to a sexually oriented offense. That means you'll be classified by law as a Tier 2 offender. A Tier 2 offender, as a result of that, must register and verify information. You must do that about yourself for a period of 25 years with in-person verification every 180 days. Do you understand that?
Yes, sir.
That is as to each case. There are also requirements for reporting if you change your address during the term. You are required to report that. Do you understand that?
Yes, sir, Your Honor.
Now, the failure to register, failure to verify residence at specified times, or to provide a notice of change in residence address or other required information will result in a separate criminal prosecution. Do you understand that?
Yes, sir.
Do you have any questions about that?
No, sir.
All right. Do you understand that if a prison term is imposed in this case, then upon your release you will be placed on post-release control for 5 years under the parole authority?
Yes, sir, I understand.
They will place conditions on you. If you violate the conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, Your Honor.
If your violation of post-release control is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, Your Honor.
And if that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time you have left under post-release control. Do you understand that?
Yes, sir, I understand.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes, sir, I understand.
You could be placed on community control for up to 5 years, but if you violate any conditions as to both of these cases, I could send you to prison for the equivalent of 21 years. Do you understand that?
Yes, Your Honor, I understand.
Now, has anybody promised you I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand at the time of sentencing, the prosecutor may make a recommendation, Ms. Snavely may make a recommendation. You understand I don't have to follow either recommendation?
Yes, sir, I understand.
Have you had enough time to talk with Ms. Snavely before pleading guilty today?
Yes, sir. Yes.
Has she discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice she has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions at this time?
No, sir.
All right. Ms. Gold, if 291 went to trial, what would that evidence show?
Thank you, Your Honor. The evidence would show that on October 15th, 2025 in Willoughby Hills and on October 16th, 2025 in East Lake, the defendant engaged in sexual conduct with minor victim AA, who is not the spouse of the defendant. The defendant knew that AA was 13 years old at least, but less than 16 years old, and the defendant was more than 4 years older than AA. On October 15th, the defendant did furnish AA with a controlled substance, being marijuana, who the defendant knew was at least 2 years younger than him.
Ms. Snavely, anything to add to those facts?
No, Your Honor.
Mr. Hopkins, did you hear what Ms. Gold said, that the facts would show if case 290 trial?
Yes, sir.
And are those facts true?
Yes, sir.
What is your plea to the lesser included offense of count 1, unlawful sexual conduct with a minor, a felony 4?
Guilty.
What is your plea to count 2, corrupting another with drugs, a felony 4?
Guilty.
And what is your plea to count the lesser included offense in count 3, unlawful sexual conduct with a minor, a felony 4?
Guilty.
All right, Ms. Gold, if 869 went to trial, what would the evidence show?
Thank you, Your Honor. The evidence would show that between August 18th, 2025 and February 11th, 2026, in Lake County, Ohio, the defendant had sexual conduct with minor victim RP, who was not the spouse of the defendant, and who the defendant knew was at least 13 years old and less than 16 during the times of each sexual encounter that happened at least once per month in the months listed in the time span of this indictment. The defendant was 10 or more years older than minor victim RP, and during this time the defendant furnished her with a controlled substance, being marijuana, knowing that she was at least 2 years older than the defendant.
All right, Ms. Snavely, anything to add to those facts?
No, Your Honor.
Mr. Hopkins, did you hear what Ms. Gold said? The facts would show if case 869 went to a trial.
Yes, sir, I did.
Are those facts true?
Yes, sir.
All right, what is your plea to count 1, unlawful sexual conduct with a minor, a felony 3?
Guilty.
What is your plea to count 2, unlawful sexual conduct with a minor, a felony 3?
Guilty.
What is your plea to count 3, unlawful sexual conduct with a minor, a felony 3?
Guilty.
What is your plea to count 4, corrupting another with drugs, a felony 4?
Guilty.
All right, Ms. Snavely? Can you have him, I wrote that he took medication. Just, yeah, in the margin, okay? Thanks.
It is. Second. That's my pleasure. Was that one? Okay, we'll do initial right here again. That side. You do it. It's the same thing. That side right here. It's just doesn't sign. It just doesn't sign. There we go.
Your Honor, I've witnessed the defendant and Ms. Snavely sign the written plea of guilty in both cases, and I have signed it myself in the court.
Mr. Hopkins, on case 291, is this your signature on the written plea of guilty?
Yes, sir.
And did you sign it voluntarily?
Yes, sir.
And do you want me to accept your written plea of guilty?
Yes, sir. I would appreciate that.
All right, I'll accept the written plea of guilty on 291. On 869, is that your signature on this written plea of guilty?
Yes, sir.
And did you sign that one voluntarily?
Yes, sir.
And do you want me to accept that written plea of guilty?
Yes, Your Honor. I
I'll
appreciate that.
accept the written plea of guilty on 869. Defendant was present with Ms. Snavely. Advised of all of his rights, being a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. Will accept his plea of guilty. And on 291, find him guilty of the lesser included offense in count 1, unlawful sexual conduct with a minor, of felony 4. The lesser included on 2, on 3 rather, unlawful sexual conduct with a minor, of felony 4, and count 2, corrupting another with drugs, of felony 4. On 869, I will accept the plea of guilty and find him guilty of counts 1, 2, and 3, all unlawful sexual conduct with a minor, all felonies of the 3rd degree, and corrupting another with drugs, of felony 4. I'll refer both these cases for a updated pre-sentence report and a psychological evaluation. The sentencing will be August 7, 2:30 p.m., and the bond is revoked. Anything further, Ms. Gold?
Your Honor, I would
And
ask
also
for-
victim impact statement, sorry.
Yes, Your Honor, thank you.
Anything further?
Not for me, Your Honor. Thank you.
Nothing from the state, Your Honor.
All right, we're adjourned.
All right.
Good morning once again, everybody. It is TCF Live on a Super Thursday this week. My name is Dan. Judging from the stats, there's probably some new people out there. If you're new to the show, do take a moment and say good morning in the chat. We're a friendly folk here. You'll find a lot of love. Trust me. From earlier, Todd, thank you for gifting a membership. Barbara, thank you for your $5 super chat and for gifting membership as well. I appreciate you both. Let's go to Florida. Wade Mercer.
Mr. Beasley, good morning. Mr. Beasley, you're here because you've been accused of 1 count of domestic battery by strangulation. Mr. Beasley, there is probable cause for the charge. It looks to me like you just got off probation last year out of a neighboring county. Is that right, Mr. Beasley?
Yes, sir.
Okay, but I think you're entitled to a bond as far as I can tell. I'm going to listen to the attorneys before I make that final decision. Mr. McDaniel, anything on behalf of Mr. Beasley?
No, Your Honor.
Corporal, I don't know if it was the power loss or something else, but we cannot see Mr. McDaniel. The camera is shifted to our left You're right. So
I try to stay out of the camera as much as I can. You know, you've seen all the Facebook posts, they've been, all those YouTube things.
There it
I
is.
try-
Before they get rolling, let me take a moment to pause and thank you, Lindsay, for gifting 10 memberships. Landed on Air Force family, a hit and a win. Thank you, Lindsay. As always, I appreciate your support.
I try not to watch that stuff, but Mr.
Nothing.
Mr. McDaniel, you said you had nothing from the state either. Mr. Beasley, I'm going to set your bond since you just got off probation, sir. Your bond's going to be $7,500 cash or surety. Mr. Beasley, cash or surety means you do not have to come up with that whole $7,500. You can go through a bondsman. So, Mr. Beasley, you'll get a chance to use the phone in a few minutes. So, if you want to post bond, you certainly can do that. You'll be released. If you do, you will have a condition of no contact with the alleged victim at all. You have no contact with the alleged victim while this case is pending, Mr. Beasley. I'm not sure. Did you live in the same residence or no?
No, sir.
Okay, so you can go to your home as long as she's not living there and not there. Mr. Beasley, you will get use the phone in a few minutes, and the jail's going to also give you a notice for your court date. That way we don't have to mail you one. We know that you get it. What will his court date be?
I think August 4th.
August 4th, sound right? July's already cut off. It's already July now. It won't be a July date, Dottie. It'll go to August. August 4th, Mr. Mitchell?
Yeah, that's correct, Your Honor.
August 4th at 8:30 will be your court date, and the corporal's going to give you a notice for that date and time. Mr. Beasley, do you have any questions?
No, sir.
Wish you the best, sir. Adam Bodie. Mr. Bodie, good morning. You're here for first appearance accused of one count of aggravated battery and one count of false imprisonment. It's case number 22548. So there's been a warrant out for a while, but it looks to me like you just got out of the Department of Corrections. Is that right, Mr. Bodie?
Yes, sir.
Okay, let me listen to the attorneys, and then I'm going to go ahead and address your bond status. Mr. McDaniel?
Yes, Your Honor. He also had to go to Holmes County. He just resolved the case, felony case in Holmes County, I guess, yesterday. He was placed on probation over there. It looks like rehab. So we just asked for some kind of reasonable release option. You know, we understand what's going to happen.
Thank you. Mr. Mitchell?
Nothing, Your Honor.
Okay, you agree he's entitled to a bond, right, Mr. Mitchell?
Yes, we do agree.
It looks to me like he is. I just want to make sure. Mr. Bodie, it's a pretty serious charge you've got. As Mr. McDaniel's already told you, I'm sure there's extenuating circumstances considering the fact you've been to prison since this allegedly happened. That's always a factor. So, Mr. Bodie, your bond on the aggravated battery is going to be $25,000. On the false imprisonment, it's going to be $5,000. Your total bond is $30,000 with a condition of no contact with the alleged victim. So you've got that condition, Mr. Bodie. You'll have the court date of August the 4th at 8:30. The jail will give you that notice. If you post bond, great. If you don't post bond, you'll still have that same court date. And Mr. Bodie, either way, you get a chance to use the phone in a few minutes to contact friends and family and tell them what's going on with your bond. Mr. Bodie, do you have any questions?
No, sir.
All right, sir. Wish you the best. We have Justin Morgan. Mr. Morgan, good morning. Mr. Morgan, the warrant in your violation of probation has been signed. I know that you have not been served that warrant yet. So I'm going to ask the sergeant to try to get the sheriff's department to serve that warrant. It was just signed this morning. Sheriff's department hasn't done anything wrong at all. But it was just signed this morning, and it's a no bond warrant. We kind of anticipated that. So now you've got a violation of probation charge that you're accused of. It's based on the new charges, Mr. Morgan. I want to go ahead and get you arraigned this morning. What that means is if you want an attorney appointed to represent you, Mr. Morgan, I'm going to do that today. Would you like to have an attorney appointed to represent you in the VOP?
Yes.
All right. I'm going to appoint the public defender's office to represent you in the violation of probation. Listen to Mr. McDaniel, and then we'll see if you have any questions in just a minute, sir.
Your Honor, we're going to plead not guilty. I set this in the August 4th pretrial docket, and I advise you that attorney will see him more likely on that day, if not before.
Thank you. So, Mr. Morgan, you've got no bond for now, at least until your court date. Mr. Morgan, so what that means is I know you got a big bond in the other cases. Even if you could post bond, you wouldn't get out. Just be aware of that, Mr. Morgan. And as Mr. McDaniel said, your attorney will see you on or before the court date. And we'll see what happens with the VOP. Mr. Mitchell, anything from the state?
Nothing from the state, Your Honor.
Mr. Morgan, thank you. Mr. Morgan, anytime your bond status changes, you do have the right to use the phone to contact friends or family so you can tell them what's going on. So you will get to use the phone after first appearance if you want to tell them you now have no bond. Do you have any questions, sir?
No, sir.
Thank you. So Judge, I talked to Judge Garcia this morning. I went ahead and signed that warrant. It was in the portal. So thank you. After Mr. Morgan, we have Evan Bagwell. Mr. Bagwell, good morning. Mr. Bagwell, I first appeared to you yesterday on a charge that I don't know I've ever seen. I'm certainly not familiar with it. After court, the clerk's office made me aware that when they went to set up the charge, it showed up in their system as a misdemeanor charge, not a felony charge. So I went back and looked at the statute more closely, and they're absolutely right. Not only is it a misdemeanor, it's a second-degree misdemeanor, which creates several issues. First of all, the bond amount that I set you is based upon a felony charge, but you're not accused of a felony, you're accused of a second-degree misdemeanor, and that brings other issues into play, like whether or not it's one of the misdemeanors that officers can arrest for occurring outside of their presence. They can't arrest for just any misdemeanor occurring outside their presence, only if they have specific statutes authorizing them to do so. And I think Mr. McDaniel wants to be heard on that issue. Is that right, Mr. McDaniel?
Yes, Your Honor. We just argued that, obviously this is not something that was in hot pursuit, or, the officer went back to his house, I think at least twice, during her investigation of this, and spoke to his fiance, his girlfriend, and him. Obviously some of the parts of the statute, seems almost difficult, if not impossible, to happen in front of the presence of an officer. She has to confirm certain things, and I think it's a case where it basically is not one that's an arrestable offense, where, the elements happen in front of the officer, especially when you take into consideration that it's only his statements that are being used primarily for, him said he's living there. I understand there's probable cause for it, definitely probable cause for it, but I don't know if there was any kind of hot pursuit or something of some kind of nature where he had to be arrested for it.
Well, I promise you.
Thank you, Mr. McDaniel. Mr. Mitchell.
I reviewed the email that Mr. McDaniel sent out to both you and me, and I agree that there are issues when it comes to the warrantless exception coming into play here. I was initially, excuse me, I was initially going to make maybe it was a good faith argument that he thought he was arresting him for a felony, but it doesn't exactly play into it when we're talking third-degree felonies versus a second-degree misdemeanor. So as for that issue, we'll just leave it up to the court to decide what's best. We just request the reasonable release option under those circumstances.
Thank you. So, Mr. Bagwell, the officer actually checked the misdemeanor on the complaint. Actually, that's the amended complaint. I don't know that I have the original
had misdemeanor also checked on it.
So the officer was right. I just missed it and thought it was a felony, and everyone else apparently did also. So the question is whether or not he can make an arrest in this situation. Considering your employment status, the fact that you got out of prison fairly recently, I don't want you to lose your job if I can help it, as well as the certainly gray area at best of whether or not you can make an arrest for this charge. There's an argument that could be made that Mr. Mitchell and Mr. McDaniel have tossed back and forth in emails, but I think the fair thing to do in this case is just give you a ROR under the circumstances. You're going to get out of jail this morning. I'm going to instruct you. You do have certain reporting requirements. If you're a convicted felon in the state of Florida, you need to take care of that immediately. But get back to work. We're going to give you a notice for your court date. Your court date will be when, Mr. McDaniel?
July 27th, 9 o'clock.
Yep.
Thank you.
July 27th, 9 o'clock. I'm going to ask Mr. Mitchell to notify the officer of. I know that this is not on the forefront of officers' minds, Mr. Mitchell, and we just need to kind of refresh their memory that in misdemeanor cases, if it's not listed in the statute or a statute, they can't make an arrest. And that's just, it is what it is. So I appreciate you talking to the officer, and maybe I'll come into some kind of, that's not something we normally cover at trainings we do every couple of years for them. That's maybe something we need to cover more frequently. So just let them know that this statute is not listed in the warrantless arrest statute. Now, there's an argument that it's a continuing crime such as theft, that you're continuing to deprive someone of the property and that he's continuing to not register, and that continuing act happens in the officer's presence. But as Mr. McDaniel pointed out in his email, that's kind of a stretch. So you're going to get out of jail today, Mr. Bagwell. We're going to see you on that court date. I need to stay out of trouble between now and then. Do you have any questions?
No, sir. I appreciate you.
Yes, sir. Have a good day. Kenneth Collier. Mr. Collier, good morning. Mr. Collier, you were taken into custody the first of this week, I believe for allegedly having, maybe it's over the weekend, for allegedly having contact with someone you were ordered not to. I told you at that time that unless the state was opposed to it, I'm probably going to set you a bond after you've been in jail several days, which you have been now. Mr. Mitchell, what's the state's position on a bond in Mr. Collier's case?
We have no objection to a bond. We would just ask that the condition of the 100 feet be amended to no contact with that property at all.
Mr. McDaniel, your thoughts?
Your Honor, he's under the impression, I think he's talked to her sister and she's going to be leaving. She's leaving or has left. I know you don't have anywhere else to go. You have anywhere else to go or?
I have no friends. I have no family down here.
I mean, you don't,
Okay. Thank you both. So Mr. Collier, I'm going to set your bond at $2,500 cash or sure. I'm sorry.
I think Mr. McDaniel was talking to him while you were talking. So.
Okay. Mr. McDaniel, anything else?
I don't think I have anything else, Your Honor. We would ask the court just to tell him that he needs to stay 100 feet away from that residence. And because I don't think he has any place else to go besides. But I think she's leaving, so.
Mr. Collier, your bond is $2,500. You have a condition, no contact with that property. I've already tried that. I've tried to give you access to that camper, and there's certainly evidence that you ignored the order and went to the home, even though I told you not to. So you can't go back to that property. Now, having said that, if she's gone and she has moved out and her belongings are no longer there, she's voluntarily left the property, or she's been legally removed, such as an eviction, you can go over there and you can live there. But if she's there or if she's living there, you cannot go on that property. So if you want to get law enforcement, I told you this last time and you didn't do it. If you want to get law enforcement to meet you there and see if her stuff is there or gone or whatever, that's fine. But you cannot go to that property without law enforcement being with you at the time. You cannot step foot on that property at all. That couple of acres there, that includes the camper. Can't go there at all. I've tried that. I'm not trying it again. So only way you're going on that property is with law enforcement. But you've got to post the bond to go back there. I'm not going to give you another conditional release under these circumstances. You do have the right to post bond. You'll get to use the phone in a few minutes. This does not change your court date. Your court date should be the same court date you were given previously, which would be, Mr. Mitchell?
27th, I think.
He's got a private attorney docket, private attorney, so it'll be whatever the private attorney is.
Oh, I didn't even think about that. Who is the private attorney, Mr. McDaniel?
It's Russ Ramey.
Has he filed a notice of appearance?
Yes.
He has?
I told him that he was in jail. I think I copied Jake on it when I emailed him, but I never heard back. I don't know if Jake heard anything or.
If you give me a second, I can give Mr. Ramey a call.
Do you mind? I don't want to address something without him being here. I did not know he had a private attorney. So just have a seat. We're going to come back to your case in just a second, Mr. Collier. I don't want to do anything without your attorney being involved, okay?
Sure.
There is a notice of appearance filed by Mr. Ramey. So we'll come back to that case. That brings us to Chevelle Belay. Miss Belay, your husband is in the courtroom. You also were taken in custody for allegedly violating conditions of your conditional release by having contact with someone you were ordered to have no contact with. That's why you were taken into custody. Mr. McDaniel, is there an agreement reached in this case, or do I need to address her bond status?
We would just ask for some kind of reasonable option, to get her out of jail.
Okay, Mr. McDaniel, Mr. Mitchell.
We have no objection to a reasonable release option. I will point out that the original condition was no contact with the victim. Mr. Belay has been in touch with us and is requesting peaceful contact. If this case was to be settled today, but we'll leave it up to the court to decide what's the best route with that.
The case has not been settled today, though, correct?
And it seems that way, yes.
So, Ms. Belay, I'm going to set your bond at $2,500 cash or surety. You have a condition of no contact with the alleged victim. That's the condition still applies. Sir, she has a condition of no contact with you. That still applies. If she contacts you and I find out about it and there's credible evidence of that, then she'll go back to jail. with no bond, and she's not gonna get out after a couple of days then. No contact means no contact. Mr. Mitchell's office is gonna decide what they're gonna do with the case, whether they're going forward with it or not, and that's their decision. But if she has a condition, no contact starting immediately, that means no telephone contact, no electronic texting or communication, and certainly no personal contact. So if she contacts you, she's violating a court order, and it's not gonna be a couple of days in jail if it happens again. Sir, do you have any questions about that? Ms. Belay, do you have any questions, ma'am?
No.
Your bond's $2,500. Does she already have a court date, Mr. McDaniel?
Yes, well, she needs to be put on the next arraignment docket, I think. What is that? Is
The 20
July 27th, 9 o'clock.
July 27th at 9 o'clock will be your court date, Ms. Belay. The jail will give you a notice for that date, ma'am, before you leave the jail. Do you have any questions, Ms. Belay?
No.
Have a good day, ma'am.
You too.
Thank you for coming, sir. So let's go back to Mr. Collier. Mr. Mitchell, any luck in getting a hold of Mr. Ramey?
I think you just saw me try twice. I wasn't able to get a hold of him.
Is that victim left yet?
No, he's still here.
So she wants to know if I told her she can't contact him, but he can post a bond.
Sir, just a second. Your wife has a question. Or sorry, Mr. McDonough, he was trying to walk out. Go ahead.
I told his wife, Ms. Belay, that she can't have contact with him, but he can post a bond. I guess her question is he going to be posting the bond for her, but with no contact with her, though?
So, sir, just because you can have no contact with her doesn't mean you can't post a bond. If you choose to post a bond for her, you have the right to do that, okay? You just can't have contact with her, okay? All right. He understands. Thank you. You can post a bond, yes, sir, if you wish to. That's up to you. Okay? Thank you. You can't drive her back. If you post a bond for her, she's got to get a ride other than you. She cannot have contact with you personally at all.
Correct. Y'all need to go through your daughter. I mean, I told her to call the daughter, so y'all need to go through your kids.
Come on up if you have a question so I can try to answer your question. Do you have a question? Come up so she can hear it too.
I think she
Yes,
already.
She has a job, okay, and she has this week off because of the problems.
Okay.
Can she go back to work again Monday?
She could go back. I hope she does go back to work. She just can have no contact with you. She's got to learn that when a judge says no contact, that means no contact. So she can have no contact with you. Other conditions she has are every bond has a condition. She can't be charged with a crime. She can't miss any court dates, can have no contact with you. That's it. She can leave the county. She can leave the state. As long as she doesn't violate those three conditions. That's the conditions of her bond.
Okay, can I pay that bond today?
You sure you can. You go to the jail and post a bond, or you contact the bondsman. That's up to you.
Okay.
Yes.
Where is a bond place around here?
There's several bond places.
Okay.
You contact the jail and they can give you some guidance and some options. Okay.
All right. Thank you.
Yes, sir. All right. So let's go back to Mr. Collier.
I'll try one more time, Your Honor. This is
okay. So, Mr. Collier, Mr. Mitchell's trying to get a hold of Mr. Ramey, your attorney.
Yes, sir. I haven't been able to speak with him either.
Okay, so that's good enough, Mr. Mitchell. Mr. Mitchell, it's okay. We tried. So, Mr. McDaniel, just a second, Mr. McDaniel. I'm concerned about taking action in his case, Mr. Collier's case, without his attorney being present, but I don't think giving him a bond prejudices him. Obviously, he's not saying anything that incriminates him in any way. Do you feel comfortable with me going ahead and taking the action I've already done, even though he has a private attorney who's not present?
Yes, Your Honor. I'm very comfortable, and I've asked the court to do that because this obviously would prejudice him if he has to stay in jail because Ms. Ramey's not here. I just asked for that court date for that private attorney. I know they got it set, but I wouldn't recall what date it was.
Oh, wait.
Mr. Mitchell?
And it was set for next week on the 9th, but we did already have the docket come out.
Is he on the 9th?
Well, when Mr. Ramey filed his notice of appearance, let's see what happened. What's the case number? Well,
26322 mm.
So we're just trying to make sure we give you the right court date, Mr. Collier. We'll get you out of here in just a minute. Dottie, why wouldn't he have been moved to a private attorney docket when when Mr. Ramey filed a notice of appearance? He should have been, shouldn't he?
Yes, he should have been.
When is the next private attorney docket?
When did he file?
It's set for case management conference 8/13. Is that a private attorney date?
Yes.
Correct. It is. So your court date is August 13th. You're already on that docket, Mr. Collier. August 13th is your court date. Make sure you contact Mr. Ramey when you get out of jail. Everything else I told you is accurate. I am going to set the bond because I don't think that's prejudicial to you. I think it actually helps you, and you have the condition, no contact. If she's out of the property, then we can deal with that. Obviously, when your attorney's present, we'll consider anything. So normally I would not even touch your case without your attorney being present, but in this case I am, because he didn't know about the court date, and I don't want you sitting in jail any longer. I don't think he would either. Do you have any questions about any of that, Mr. Collier?
Yes, sir. If she's out of the home, I just call the police and the police will go and verify that she's out of the home.
You would contact law enforcement that has jurisdiction over that area. What they would do is they would go with you. They probably would meet you down the road somewhere and accompany you to the home. And if they verify that she's gone and her belongings are not there, then you're free to live there. If her belongings are still there and she's just gone to the store or something, then you get what you need to get, your clothing wise, and you go somewhere else, not on that property.
Yes, sir.
Any other questions?
No, sir.
Yes, ma'am.
Jake, that's 1:30.
Just a second, Mr. McDaniel. Miss Dottie has a question. So her request, Corporal, is that y'all go ahead and give him notice for that court date. Also, Mr. Ramey probably will, but just to make sure he gets his notice, give him a written notice, please, for August 13th at 1:30. Mr.
Yes, sir.
McDaniel. Thank you.
Nothing else, Your Honor.
All right. Wish you the best, sir.
Thank you.
Is that it? So, Mr. McDaniel, it's everything I had on my first appearance list. Anything else from the Public Defender's Office?
No, Your Honor.
Thank you, Mr.
All right, that's the end of the day for Wade Mercer. Let's head back up to Michigan and check back in with Judge McNally.
89829 and also, your name? All right, so. Oh, good. Okay. All right, ma'am. You have a show cause here. It is alleged that you failed to pay your fines and costs as ordered, balance owing $895. That is count one. Do you understand the charge, ma'am?
Yes.
Count two, that you failed to submit the weekly testing as ordered on June the 4th of 26. Do you understand the charge?
Yeah.
Count three, you failed to submit the weekly testing as ordered on July the 17th of 26. And count four, that you failed to submit the weekly testing as ordered on June 22 of 26. Do you understand those charges?
Yes.
Those are all technical violations. And then it's also alleged that you failed to pay for a scram tether. So you have 5 counts. Do you understand all those charges?
Yes.
You also have a non-technical violation, which is commission of a crime. They think that you were convicted of driving while license not valid. Through the 33rd District Court. Through this court, offense date was May the 25th of this year. Do you understand that charge?
Yes.
So if you plead guilty, or if you're found guilty, given the number of violations that you've had, You could be incarcerated on this case for the maximum provided by law, which in this instance is up to 93 days with credit for any time that you've already served. Do you understand that? Did you sign, read, and understand this advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that? All right, you have the right to a lawyer. I'm going to give you a lawyer. Fair enough?
Yes.
All right, so I'm going to enter a not guilty plea for purposes of arraignment. I'll give you a lawyer, and you will go meet with the lawyer, and then you will come back in front of me, okay, with your lawyer. Any questions? Good luck. Thank you. You can go right out in the hallway. John, we need the probation lawyer on that one. Reed Dean Labadie Jr., 25WA2910.
I didn't get what you said it, I'm sorry.
She needs a lawyer, Ms. Dean Ely. Your name, sir?
Reed Labadie Jr.
All right, you're charged with a violation of probation. Well, first of all, I placed you on probation back on February the 4th of 26. This was a window peak charge, and I have a charge that you failed to refrain from consuming alcohol that you submitted to a PBT administered by the Flat Rock Police Department on April the 18th, 26, with a result of 0.124 blood alcohol content. That's count one. Count two, you failed to refrain from violating the law, being convicted of operating while impaired on May the 14th of 26. The offense date being April 18 of 26. That's the same date that you tested positive allegedly on the PBT. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and we are not going to have a hearing or a trial. Do you understand that?
Yes.
All right, you have the right to a lawyer. I'm going to give you a lawyer, okay?
Okay.
So I will indicate you want a lawyer. I will enter a not guilty plea. We will give you a lawyer on this case as well. Any questions?
No.
All right, good luck to you.
Thank
You'll come back in front of me either way after you and your talked.
Tim gifting 5 memberships. Thank you so much again, sir. You've been very, very supportive of me, and I appreciate it. And it looks like you hit Blazer, who said good morning to us in the chat. So, hitting a win. Thank you, sir.
Can't not show up. Yeah, would you please call her? Does she know that?
I don't think so.
Tony, you have Mr. Osmond's case. Amy Gate didn't show up. Would you find out what's going on? Here's the overflow. Thanks. Thank you. People against Stevens disposal, 260-648-809.
Yes, good morning.
Mr. Osmond, your appearance?
Yes, sir. Good morning. Jeff Osmond on behalf of Stevens Disposal.
All right. So there was a warning on the prohibited truck route, and the defendant's charged with defective equipment, and there's going to be a plea to impeding traffic commercial vehicle. True?
Yes, sir.
And you're authorized to enter into this arrangement on behalf of the defendant, correct?
Yes.
To that charge, commercial vehicle impeding traffic, responsible or not responsible?
Responsible.
Plea is accepted. Original charge dismissed, $200. I'll give until July 16th, okay?
Okay, thank you.
Thank you. Have a good day. Enjoy your 4th.
Yes.
Barbara, thank you for gifting another membership. Appreciate you as well. Let's change it up back to Lake County, Ohio. Fresh contestant in front of Judge O'Donnell.
We are here on the matter of the state of Ohio versus James Maxey, case number 25 CR000468. The defendant is present in open court with their attorney, Nicolette Tomzik. We are set today for a sentencing hearing after the defendant previously pled guilty to tampering with evidence, a felony of the 3rd degree, possession of cocaine, a felony of the 5th degree. Since then, a pre-sentence report has been completed. The defendant has 33 days of jail time credit.
Ms. Tomzik.
Yes, thank you, Your Honor. We'd like to ask the court today for an opportunity to place Mr. Maxey on community control sanctions with treatment. Your Honor, Mr. Maxey, while out on bond, I understand that At the outset of this case, his bond was revoked. Your Honor did reinstate his bond at the change of plea. Mr. Maxey did complete an intake assessment at Signature Health. He did do the assessment to enter into trauma counseling, see a psychiatrist, and start substance abuse rehab at Signature Health. He was planning to do intensive outpatient. Your Honor, he also did complete the jail treatment program through Painesville Municipal Court when he was on probation with them. With regard to the jail treatment program, he really enjoyed it. He said it did help him a lot. Your Honor, I do understand that upon entering the jail when he got picked up on the warrant, he was positive for cocaine, methamphetamine, and amphetamines. I did speak with Mr. Maxey regarding that. He indicated it was a mistake. He did meet up with one of his old friends and accidentally did take one hit. He understood what he did.
Accidentally?
I'm sorry?
Accidentally?
Per Mr. Maxey, yes. It was Mr. Maxey, I'm sure, would be more than happy to touch base on what happened there. Your Honor, while Mr. Maxey was out, things have been going better for him. He indicated he now has a relationship with his daughter. He has been speaking with her more. He was homeless. However, he does have a place that he can live now. He could live with his stepdad and mentor. Your Honor, Mr. Maxey has never done court-ordered treatment. He has done treatment prior on his own. This is his first felony offense. So we'd like to ask the court today for an opportunity to allow Mr. Maxey try treatment at Signature Health to get start the trauma counseling and speak with Mr. Maxey in reading his pre-sentence report. He does believe his childhood trauma is quite a bit of the reason for his underlying issues. Thank you.
Maxey, what do you want to tell me before I impose sentence?
It wasn't an accident. What happened was me and my girlfriend at the time had nowhere to sleep. Someone was supposed to give me some money to get a room, but they were cleaning warehouses and they were going to be done at midnight. We had nowhere to go. It was about 40 degrees out and raining. We ended up falling asleep in underneath a tree in the field over there where the old Harvey High School was. We woke up, it was about 2 o'clock in the morning. I needed to use a phone to contact this person. I walked down there, and the whole reason we were outside is I was avoiding everyone that used. We got there, they handed me a phone and a pipe, and I hit it out of natural instinct. It wasn't an accident. I got pissed, excuse my language, I threw the pipe down, and I left. I proceeded to walk down the road where I walked directly into a cop, pretty much. And at that point, I was okay with that. Not walking into a cop. I knew what I don't want to go back to that life. That life's been horrible to me. I've traded my kids, everything for drugs my entire life. I realize that now. And I never understood why I was the way I was. Being molested as a kid affected me to depths I never understood until JTP. JTP went over that, we had to look at our lives and look at the emotions and the feelings, and coupled on the fact that, I've lost my whole family in the last 4 years. My mom, my brother, my sister, everyone's, and I really I was on a downward spiral that, to be honest, this case saved me.
Why did you disappear back a year ago?
A year ago, I had missed court because my boss's truck broke down and I couldn't get there. And at that point I was terrified. I didn't know what to do. I'd never been in this position. I've never had a felony before.
You've had plenty of misdemeanors already.
Yes, I've had plenty of misdemeanors.
You know how court works.
Yes, I do.
So it didn't come as a big surprise that you were arrested on this, right?
No, not at all, Your Honor. I'm not debating that at all. I'm 100% wrong. I've been wrong the whole time. It's just I've never had consequences like this. To be honest, I've never really cared. Up until I lost my mom, my brother, and my sister, I didn't care about much. It made me look at myself.
When's the last time you had a license?
About 5 years ago, I think.
What are you gonna do about that?
I want to get one. I know I can get it now. I just need to pay off some reinstatements.
How much?
I'm not positive, to be honest with you, Your Honor. I know it's not ridiculous. It's something that it's feasible.
When's the last time you worked?
I always work. I have a job now.
Where?
I work for basically myself, but I'm subcontracting through Mike Sawyer.
Doing what?
Painting.
How much do you work?
And during the seasonal hours, for at least 40 hours a week. In the winter, it gets a little slow for a couple months.
So what do you do when it gets slow for a couple months?
I try to work with other people doing other odds and ends, construction, concrete, whatever I can, to be honest with you, Your Honor.
Anything else you want to say?
No, I mean, I apologize to the court for everything that's happened, and my actions. That's all I can really say, Your Honor.
All right, Mr. Knopf.
Thank you, Your Honor. The state's recommending community control. However, we would be recommending NeoCap. The defendant has a criminal history that mostly involves drug offenses. There's no violent or serious offenses. There are some contempt of court. And in this case, he did violate bond. He committed multiple bond violations, which I think would demonstrate that when he's out on his own free will, he's not willing to listen to court orders. So I think a heightened level of community control via NeoCap would be appropriate. So again, the state would recommend community control.
How long have you been using drugs?
I started using when I was 12.
All right, I've reviewed the pre-sentence report and the Lake Geauga evaluation. And I've reviewed the letter I received, listened to counsel, listened to Mr. Maxey, considered all the provisions in 29, 29, 11, 12, and 13. I'm going to put you on community control for 4 years, 93 days in jail with credit for 33. You're going to enter into the program at either Lake House or Concord Pines as soon as a spot is available, and then the remaining days will be suspended. Complete that and follow the recommendations. No drugs or alcohol with screens. Get a comprehensive mental health evaluation and follow all the recommendations. You're to utilize only one doctor and one dentist and one pharmacy for prescription medication. Take your medication as it's prescribed only. Sign releases for probation. Obtain and maintain full employment. Get a valid driver's license and pay the cost and supervision fees. In this case, Mr. Clement, any other terms?
No, Your Honor.
You understand all the terms?
Yes, Your Honor.
If you don't comply with the terms, the state will file a motion to terminate your community control. And if I find you violated, you potentially face 48 months in prison. You understand that?
Yes, Your Honor.
All right, is there anything further, Mr. Knopf?
No, Your Honor, thank you.
Ms. Tomaszek?
No, Your Honor, thank you.
All right, we're adjourned.
All right.
Hour 2 of TCF Live on this Super Thursday this week. Barbara gifted a membership. Thank you for that. Todd threw down 7 more. Thank you for that. I know you guys are targeting somebody. Continued good luck with that because you seem to be hitting everybody but I appreciate the generosity, and undoubtedly so do our new channel members, so thank you. Let's go back to Michigan. Judge Simpson, check in with him.
From this honorable the office of the defender. While the people do not believe that any step of conflict exists, we make this waiver in the avoidance of all doubt.
Yeah, Michael Gaddy, Assistant Public Defender. I concur with Mr. Cook. The Public Defender's Office does not believe that there are any conflicts to the extent that any were to exist. we would waive any such a conflict.
All right. Court for its part also does not believe there's a conflict either under Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the case of the people of the state of Michigan versus Micah Daniel.
And good morning, Your Honor. As Mr. Public Defender cannot be carried, I can really, on behalf of Mr. Micah Daniel, he is on the screen. Mr. Daniel, could you state your name for the record, please?
We're trying to unmute.
Mike Daniel.
Thank you, sir. What are we doing?
Your Honor, can we approach, please?
Really, first thing?
First thing.
Yes.
Sorry, Judge.
Please.
Thank you.
So yeah, really, first thing, I kind of agree with Judge on that. We're in the way back machine though, so let me knock this past here.
I understand this case may be holding his. You guys are trying to work something out. So what I'll do is I'll adjourn it out to hopefully there could be a resolution and get this on its way. So I'll adjourn it to July 16, 2026, 9 a.m. Bond will continue. All right. Thank you. Thank you, Mr. Daniel.
Thank you.
We'll expect a green sheet sometime today. Oh, you haven't? Shocking. Court does call the case, People versus Amber Dunson.
Morning, Your Honor. Stephanie again on behalf of Ms. Johnson, who's appearing by Zoom.
Dunson, state your name, please.
Amber Dunson.
Thank you.
And Your Honor, I'm asking for a 2-week adjournment. I filled out all the paperwork to see her by Zoom. At least I tried to, or registered my P number, my ID, everything else, but they never responded back. So I'm asking for time to go see her in person.
All right. Well, is she in Oakland?
It's in Oakland, Your Honor. Looking at their register of action, there's no anticipated release date for her. So
I'll adjourn it to July 16, 2026, 9 a.m. Bond continuing.
thank you, Your Honor.
Thank you, ma'am. Court calls the case, People versus Thomas Robson.
Office for the People.
Michael Gaddy, Assistant Public Defender. Robson, Your Honor. Mr. Robson, yeah, there he is. Sir?
Yes, Your Honor.
State your name, Mr. Robson.
Thomas Robson.
Thank you.
Your Honor, I did make attempts to visit Mr. Robson. I did fill out the paperwork for the Saginaw facility. I was hoping to get that done this week. We were not able to accomplish that. I have been approved, I believe. I'd asked for a very short adjournment to go visit him. There is no Zoom thing there, so I have to go visit him.
Yeah, there's no, I got you. Will 2 weeks be enough time for you to get that accomplished, or?
Yeah.
Okay.
I have to go there anyway.
July 16, 2026, 9 a.m. Bond continued.
Thank you. I'll come visit you, Mr. Robson.
All right, thank you.
Court calls the case, People versus Robert Drobashevsky.
The court shall cease to Assistant Public Defender on behalf of Mr. Drobashevsky, who is approaching the podium. Please state your name for the record, sir.
Drobashevsky, Robert.
Thank you, Judge. I believe you're in receipt of a competency report.
I am.
I believe at this time we'd be willing to stipulate that report.
All right. Court would find that at this time the defendant is incompetent to, based upon the report, incompetent to stand trial. Court will make that finding and sign the order once it's presented to the court, making that finding. I will then set a competency review hearing for October 1st, 2026, 9 a.m.
Very much, Judge.
Thank you.
We'll come see you before. Okay?
All right.
Take care.
Bond will continue.
Thank you, Judge.
Court calls case People versus Robert Anderson.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Robert Anderson. Your Honor, he is on Zoom, but he just got the information. Ms. Enda and I were gonna adjourn this out because of a number of additional discovery issues. Judge, can I waive his presence, Judge? He's always been here the last 3 times. Or do you want to pass?
Waive his presence.
Okay.
Don't want to
pass it. Yes, thank you.
Will, but I don't want to.
I know, 2 minutes, Judge, you'll be on, so.
Court calls the case People versus C.F.R.A. Kent.
Good morning, Your Honor. Jacob Kent, TCF on Diesha.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Kent, who's here to my right. State your name, Mr. Kent.
C.F.R.A. Kent.
Thank you.
Your Honor, I'm asking the court to adjourn this 2 weeks. There's one piece of discovery I need to review. And I think we're gonna move this file then.
Not objection, July 16, 2026, 9 a.m. Bond continues.
Thank you.
Court calls the cases of, are they court calls cases of the People versus Matthew Kennedy.
Your Honor, agreement to cook for the people.
On Zoom. Oh, where? Oh, he's out.
He's out. Yes, Your Honor.
Thanks.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Matthew Kennedy. Your Honor, discovery is complete. We're requesting an exam in this matter.
What's my date? People have their witnesses available the 14th.
Sure, Mr. Home.
All right. Preliminary examination in these matters will be set for July 14, 2026, 9 a.m. before Judge Washington.
Thank you, Your Honor.
Bond will continue. Court calls the case of the People versus David Sarfo.
Good morning, Your Honor. Marcia Crater standing in for the attorney of record, Mr. William Amadeo. Sir, could you please state your name?
David Sarfo.
Your Honor, the defendant wishes to proceed to exam. I'm not sure if discovery is complete. I advise.
Oh, where's Mr. Amadeo? Because I got to know that discovery is complete.
Well, Mr. Amadeo, I believe, is in Lansing today, sir.
So you have no indication whatsoever on the status of discovery?
My indication is that from Mr. Amadeo, that discovery is not complete. I've advised this to.
What's missing?
I believe some media, Your Honor. That was a couple days ago.
Yeah.
Okay, all right.
So he was appointed a couple days ago. You don't have his appearance, so you can't send him to media, and he wants me to set it for exam. Not gonna happen.
Okay, then can we have a short adjournment for 1 week?
Probable cause conference will be adjourned July 9th, 2026, 9 a.m. And you can let Mr. Amadeo know that I am displeased. Thank you. Bond continued.
Thank you, Your Honor.
Court calls case People versus Morgan Gaylander.
Good morning, Your Honor. Next, I honor requesting permission to practice pursuant to Michigan Full Rule 8.120 under the supervision of Assistant Prosecuting Attorney Ashley Phillips.
He's so tall. It's like I don't want to even say no, right? Permission to practice is good.
I guess I won't object to you then, Judge. Yeah. Good morning, Your Honor. Sorry, may it please the Honorable Court, David Burgess on behalf of Morgan Gaylander.
Your name?
Morgan Gaylander.
Your Honor, discovery is complete. We're requesting exam.
People have their witnesses available to 14?
We'll try our best, Your Honor.
You don't know that. No kidding. All right. Preliminary examination in person be set July 14, 2026, 9 a.m. before Judge Garwood. Bond will continue. Thank you. Court calls the case of the People versus Jason Smith.
Morning, Your Honor. People.
Good morning, Your Honor. James Fifelski appearing on behalf of Smith, who is approaching. Please state your name, sir.
Jason Smith.
Your Honor, I believe all discovery is in, and we are asking the court to set this for preliminary exam. If I may address Bond briefly.
People have will they have their witnesses available the 14th? Preliminary examination will be set July 14, 2026, 9 a.m. before Judge Washington. As to bond.
Your Honor, I would just ask the court to consider a 10% bond with a tether. It would still be a significant bond. He's been in custody since June 9th, and that would still for his presence as well as the safety of the community.
Sounds.
At this time, the city case over on the leadership retaliation for another shooting. The lead report against shooting. And it was the driver all four different shell cases were recovering. We see 4 victims of the car. And then it was one of the actual shooters, not just the driver, get the shooters to this incident. I know that the victim was shot at the hospital to get surgery in order to get the bullet removed from her arm. I would also note, I believe the defendant was on probation for CC. Having been on for just over a month of this offense, so I'm concerned about his ability to comply with court orders. I'd be objecting to any.
Anything else?
My understanding is he completed his hideout probation, and that was discharged, dismissed, and there is no evidence.
Or after this offense date?
Before, Your Honor.
Maybe CCH is not correct on that, because I'm seeing May 6, 2026. CCW for item, maybe it's incorrect on that, that's what I see.
Well, given the nature of the offense and the allegations in this case, motion for bond reduction to 9 for believes it's set appropriately. Thank you. We'll continue. Court does call the case, People State of Michigan versus Autumn Miller.
People.
Morning again, Your Honor. May it please this honorable court, David Burgess on behalf of Autumn Miller, who's approaching.
Your name, ma'am?
Otto Miller.
Thank you.
Your Honor, we just got this case, she was just arraigned recently, and we're requesting an adjournment for discovery purposes, Judge.
Probable cause conference will be adjourned July 23rd, 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you.
I gotta get.
Okay,
All right.
thank you.
Thank you. Court calls case People versus Lorenzo Murphy.
This public defender Zach Finney with on behalf of Mr. Murphy as to the case ending 5118.
And Your Honor, David Burgess on behalf of Mr. Murphy in the case ending 5119.
Murphy here.
He's in custody, Judge.
Oh, he's in custody.
Please state your name when you get to the podium.
Lorenzo Murphy. Thank you.
Your Honor, discovery is complete in our matter. We're requesting exam.
And Your Honor, we would also be requesting an exam in our matter. Disregard the green sheet. To discover.
What witness available the 14th? All right, preliminary examination in both of these matters will be set July 14, 2026, 9 a.m. before Judge Garwood.
Judge, could we briefly address bond? Just briefly, Your Honor, he's on a personal bond, Judge, but there's a tether provision. He is from St. Louis. I've spoken to his wife. She's trying to get him an Airbnb and or a extended stay hotel, but he's been in custody for I think almost a month, Your Honor, at this point. And the magistrate obviously deemed it the only reason was for the tether. He can stay at Delanis in the interim until he gets the place to stay. But Judge, I'm asking the court to consider lifting the tether provision.
Well, it's a GPS location tracking tether.
Correct, Judge.
He has no ties to this community.
I will tie myself to this community if I have to.
Your Honor, I understand that. It is, obviously the court understands. Pardon? You understand the issue we're having, Judge. So.
I do. And motion for bond modification is denied. I'm not going to change. All right.
Deal with it again for this.
Thank you.
You're all set.
Court calls the case of the people versus Jacob Ashton.
Ready to go. Does she have it?
Your Honor, Stu Bernstein, on behalf of Mr. Ashton. Please state your name. Jacob Ashton.
Thank you.
Requesting an adjournment for resolution, Your Honor.
In both matters?
Yes, please.
You're on both matters. Preliminary, or not preliminary, probable cause conference will be adjourned July 23rd, 2026, 9 a.m.
Thank you.
Bond continue. Thank you. Court does call the case of the people of the state of Michigan versus Kevin Chibarney Lowry.
Ready to go. For the people here.
Good morning, Your Honor. Sam Bernstein with and on behalf of Kevin Lowry. That would not be Lowry.
Who's not, who's Lowry? Who is, okay, well, who is he? Rowley?
That's my.
Rowley. Okay. Are you ready?
I'm ready.
Then give me the file. And
Give
then,
me this one. I'm gonna need
all
this.
right. I'll pass that previous matter. Court will call the case people versus Lauren Rowley.
Rich Hand on behalf of Lauren Rowley, Your Honor. Clerk, can you please state the record?
Lauren Jamar Rowley.
Thank you. All right. What are we doing?
Honor, in front of you, you got a request for adjournment. I would like, if I can get Lauren qualified for felony treatment court. It's probably going to require, case is going to have to be screened, assessed, interviewed, and obviously, given the nature of the charges, have to be some begging and pleading involved. So if we could have an adjournment for a month, I think that would give me enough time to see what we can do.
Any objection from the people?
Not the request for adjournment, Your Honor. I'm not sure if we qualified or not. Based on the charges.
Right. Okay, I can do the 30th of this month, or I can do the 6th of August.
30th would be fine.
Probable cause conference will be adjourned July 30th, 2026, 9 a.m.
I do have a second request.
That's why we weren't going to call Shan's case.
The entire offense involved massive amounts of alcohol and drugs, and I know he benefit from inpatient residential treatment. And I asked the court whether they would be willing to consider a release to inpatient residential treatment if we can find him a bed.
Your Honor, I have opposed to any change in bond at this time, including a release to residential treatment. In this case, police were sort of just driving around and checking and noticed a red truck parked parallel near the Carpenter Road Target at about 6 o'clock in the morning, parked between the concrete barriers and the actual buildings. So closer to the building and the vehicles are supposed to be able to get. Pittsfield officers made contact with the defendant, who was laying parallel to the truck on the concrete ground between the truck and the buildings. They made contact with him and they noticed that he had 2 machetes in his belt, was wearing a Halloween mask, happened on June 22nd, and had a wig nearby as well. After they looked at his face, they noticed his face was covered in some sort of blue paint or blue makeup. They made contact with him. He was obviously intoxicated. They looked through the window of the truck and they saw weapons. They got a search warrant for the truck. And in the truck, they found an AR-15, full magazine, safety set to fire, 3 additional magazines for the AR-15, 1 with KR, 1 in the backpack, and 1 in the drug case in the back seat. They found a shotgun with an attached knife or a bayonet loaded with 5 needles, an additional black face covering, an iPhone. There's a search warrant pending on the phone, a holster in a black backpack in the front seat of the car, a handgun in the center console, and a Milwaukee knife located on the driver's seat, as well as a trauma pack medical kit. So the people are extremely concerned about what may have been the plan or what this might do if released. Frankly, I think the bond just said is more than fair, and I ask the court continue at this time in the interest of public safety. I do acknowledge the defendant has no prior criminal history whatsoever.
Your Honor, I said up front the charges are serious and I understand, but my client, obviously the level of intoxication from both alcohol and drugs is really severe, and I think treatment would be the best option. And I understand court's reticent at this point in time, but we're gonna do what we can.
Oh, you don't even.
I know.
Reticent, but go ahead.
All right, we're gonna do what we can to help him. I think Lauren's looking for treatment, looking for help, looking to be able to find a way to become comfortable. So
I've got to make sure nobody's killed in the entry.
I,
So motion for bond reduction is denied and any modification is denied.
all right, thank you, Your Honor.
Bottom right of your screen, can you ask her what her name
Is she in?
right there?
Ma'am, there's a individual in custody. You're sitting in a corner. I'm not sure. Are they down below?
No, I believe it's Huron Valley.
Are you, and you may be at Huron Valley. Can you tell me your name?
Jamila Bounds.
Got it? Okay. Court does call the case. People versus Jamila Bounds.
Your Honor.
Morning, Your Honor. I'm Zoe Hutchins on behalf of Jamila Bounds.
All right. She's already stated her name. What are we doing?
Your Honor, we're requesting an adjournment on this matter. We've reached out to the MDOCU to request a visitation. We haven't heard back to get it scheduled, so we need to have some communication with.
Are you going to be able to get that accomplished in 2 weeks, you think, or?
I'm hopeful.
July 16, 2026, 9 a.m. Bond continued. Court calls case People versus Tyler Foland.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Folan. Mr. Folan, can you please state your name for the court?
Tyler Folan.
No, I'm kidding.
Kevin's up next. We're asking for an adjournment for resolution, please.
We'll adjourn the matter without objection, July 23rd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus, I'm hoping, Kevin C.F.R.A. Lowry.
Sam Bernstein for Mr. Lowry.
Yes, this is him.
Kevin Williams, C.F.R.A. Lowry Jr.
There's a lot of discovery. We just need some more time to go through it.
All right. You have 2 weeks work or?
2 weeks or the July 23rd date is fine too.
Without objection, I'll adjourn this matter to July 23rd, 2026, 9 a.m. On continue.
Your Honor.
Oh. Court calls case People versus Kevin Kelly Ott.
Morning, Your Honor. Sam Bernstein with and on behalf of Ms. Ott. Coming up.
Kelly Ott.
Thank you.
We're working on a mental health screening, Your Honor. Hoping for an adjournment.
For the court, how much time is that?
I would ask for at least 3 weeks to be safe.
Okay, why don't I put it out to the 30th? I'll adjourn this matter to July 30th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continue.
July 3rd, thank you, Your Honor.
Yes. Court calls case People versus Norman Johnson.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Johnson.
Norman Johnson.
Thank you.
Your Honor, we're asking to continue to preliminary examination.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 14th. Preliminary examination will be set July 14th, 2026, 9 a.m. before Judge Washington. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case People versus Joshua Freeman.
Next are not people, Your Honor.
David, I want to bring on behalf of the defendant. Do not.
Joshua Freeman. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000 cash surety.
Thank you.
Thank you, sir.
It's TCF Live on a Super Thursday this week. This will be our last live show of the week, but we will, of course, be back Monday, just taking a little extra time for the holidays. And quite honestly, there's not really going to be any court tomorrow. Let's keep an eye on Judge Simpson's court. We'll go over to Judge McNally. FYI, we normally do this on Fridays, but we will have Dungeon Court in the third hour today, so that'll be fun. And I'm debating whether or not to show you guys something else that's different as well. So we'll see what the third hour brings. Anyways, Judge McNally.
I also have Stackpole. Stackpole, have a seat up at the table here, please. Your name, ma'am?
Yeah, my name Roberts.
You're charged with violation of instructional permit, leaving the scene of a property damage accident, and false information to an officer. You have the right to a lawyer. If you would like an attorney, I'll be happy to provide you with one at public expense. Do you understand that? Yes?
Yeah.
Would you like an attorney?
No.
I'll go ahead and arraign you and I'll send you to the prosecutor then, okay?
Okay.
It is alleged that on June 12th of 26 at 6:21 p.m. that you operated a motor vehicle on Adams near Grandview and Gibraltar, and that you violated your instructional permit. That is a misdemeanor punishable by up to 100 fines, 90 days jail, costs, or all of those. Count 2 alleges that you did leave the scene of a property damage accident. That is a misdemeanor punishable by up to 100 fines, 90 days jail, costs, or all those. There would be 6 points. Do you understand that?
Yes.
Count 3 alleges that you provided false information to an officer. That is a misdemeanor punishable by up to $100 fines, 90 days jail, costs, or all of those penalties. Do you understand that?
Yeah.
Did you sign, read, and understand the advice of rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights on the advice of rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. You still wish to waive your right to a lawyer?
Honestly, I'm not sure.
Hang on one second.
Yeah, we're calling right now. They didn't, no one told us, so I didn't know.
Okay. Jeez. I'm sorry. What did you say?
I'm not sure. I've never heard of. Do you want to give us?
Well, then let me give you a lawyer.
Okay.
I don't want you to be upset about anything right now, okay? I'll give you a lawyer. I'm gonna enter a not guilty plea for you. $500 personal bond that will cover all of these cases. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as direct. Do you understand all of that?
Yeah.
All right, so we'll give you a lawyer. The lawyer will talk to the Gibraltar City Attorney, and then he or she will talk to you, whoever the lawyer's going to be, and then you'll come back in front of me, okay?
Okay.
Good luck. We'll see you back here in a few minutes. Stackpool. Noah Jackson Stackpool, 260-647-949. Your name, sir?
No, Jackson, exactly.
Where you been? Yeah.
I've been in Michigan,
You been in where?
Adrian, Michigan.
I know, but why didn't you show up?
I was in the hospital during the time of the big stop.
What hospital were you in?
It's called Bronson Facilities.
When?
21st, so the 20th to the 26th, pre-trial was the 21st.
Of May or? Why didn't you show up May the 7th? You're supposed to be here, I'm sorry, May the 21st, I mean. Why didn't you show up May the 21st for your pre-trial?
That was a pre-trial. Actually, through that.
I got a notice right in here. When I told you that on May the 7th, you were supposed to be here May the 21st. Why not here?
So I was in the hospital. I misspoke. Said I was in June 21st. June 20th, June 26th. It was May 20th, 26th.
Then why didn't you show up when you were supposed to be here on June the 22nd? Well, I don't either. Listen to me. We're gonna get through the case, okay? Got it? Okay. Got to get through the case, right? Did you go in and talk to the prosecutor yourself today? Do you have a lawyer?
Yes, he's in the office.
Oh, jeez. All right, my mistake. Why don't you have a seat right behind you? And as soon as Mr. Slop comes in, I know he's real busy.
I'll wait, Judge.
Yeah, just have a seat at the table there.
So Tot, thank you for gifting a membership. She says, I think we all need to make it a goal to get Julie a membership today. Well, let's try. We'll try our best. I had 5 to give myself. Julie herself gifts 5. So thank you. And we'll let it click away. And nope. So we've reached that special point in channel size where YouTube allows me to gift some free memberships from time to time. So I tried to help as well. Sorry, I missed. Back to Judge.
You understand that?
Yes.
You still have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer? You waive your right to a lawyer?
Yes.
To the charge, no valid operator's license on person. How do you plead? Nice and loud.
Yes.
On May 29th to 26th, were you operating a motor vehicle on Fort, Marion and Trenton at 11:13 p.m.?
Yes.
Did you have a valid operator's license on your person at the time?
No.
Are you on probation or parole?
No.
Anybody force you to plead guilty? I just want you to understand, and listen, I don't want you to say anything about your immigration, about your status as a citizen. There could be consequences, immigration consequences, as a result of this plea. Do you understand what I said?
I'm not Mexican.
Well, I don't know what you are, where you were born, and I don't want to know. I'm just telling you, if you're,
Okay.
there could be immigration consequences as a result of this plea and conviction. Do you understand that?
Yeah.
You're Spanish, right?
Puerto Rican.
Okay. Anybody force you to plead guilty?
No.
And you still wish to plead guilty, correct?
Yeah.
All right, I'll accept your plea. I find it to be an accurate plea. I'll dismiss the suspend. Anything you'd like to tell me? What are you doing to get your license back here?
Gotta wait till for
You gotta wait till what?
to
Oh, I see. You're suspended until actually the 5th, right?
yeah.
All right, 100 fines, 70 costs, 75 victims' rights, $50 justice assessment, $295 or 30 days, okay? Can you pay that now? We're not open tomorrow. Do you have anything today or not?
Later. Later.
How later?
Like.
Okay, can you pay it all then? $295. All right, I'll just give you until noon today, okay?
Thank you.
Good luck.
So Julie, do me a favor and make sure you have receiving gifts turned on in your account. Tim, thank you for 5 additional gifted memberships. That's a ton from you today. And Lindsay, 20 more. I think that's 30 from you today. So thank you so much. I appreciate everything you guys do for the community, but I say this all the time, and I'm going to continue to say it. The generosity that you guys show me and show the community, it never goes unnoticed. I'm incredibly grateful and humbled by all of you. So thank you so much.
Speak Spanish.
You don't speak.
I got it. Come on up here, ma'am. Are you with him?
No, I heard it.
I'm not sure how I didn't have a Spanish interpreter at the time of the plea, though, Heather. I don't think you ever had a Spanish interpreter before. He pled guilty to operating while impaired. Listen, why don't we get him let's get him a Spanish interpreter and try to convey that to him on that device, will you please?
Hey, Judge, I have Evelyn on the phone. I just realized that we had him here today. Is she, if he wants to wait, she can get on. She's in a breakout room on a case right now, but I believe she said she could get on right after. Is that correct, Miss Villarreal? Yes, as soon as she's done with the case, she could get on our Zoom.
Okay. John, you're gonna have to help him. Take him to a breakout, take him to a computer and help him get set up or have one of those guys.
Yeah.
Do it down the hall. Okay? Let's try to get that resolved today. Wait 1 second. All right? I don't know what to say.
Bikinis.
I know.
One.
Go with him. Go with him. Follow him. Okay? Read.
Thank you.
Or read rather. Diesha, Santoya, Kenya, Read. If I'm calling any of you that have lawyers, just tell me that, okay? This is 260-648-670. Okay, your name?
Diesha Santoya, King, get ready.
All right, so you met with the prosecutor and he's offered you the following.
Yes.
I have A and B files and C files. So you got a speeding, drive while suspend, and no insurance. And as I understand it, he's going to dismiss the driving on a suspended and the speeding if you plead guilty to impeding. Plead responsible to impeding, plead guilty to no ops, and responsible to no insurance. Is that true?
That is true.
If you plead guilty to no operator's license on person, the possible penalties are up to 100 fines, 90 days jail, costs, or all of those. Do you understand that?
Yes.
If you plead responsible to impeding, that's 0 points. And the speeding would be dismissed then. Do you understand that?
Yes.
And if you plead responsible to no proof of insurance, that's a 0-point civil infraction. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights form?
Yes.
If you plead guilty to no operator's license on your person, you'll be giving up all of those rights and we're not going to have a hearing or a trial. Do you understand that?
Yes.
All right. You still wish to waive your right to a lawyer?
I do.
To the charge, no valid operator's license on your person, how do you plead?
Guilty.
Were you operating a motor vehicle 24-26 in the city of Trenton, County of Wayne on Fort near Flucy at 1:37 p.m.?
Yes.
Do you have a valid operator's license on your person at the time?
No.
Are you on probation? Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
What are you doing to get your license back?
What am I doing to get my license
Yeah.
back? I'm going to each of the court dates. I just moved. That was the issue. I didn't get the paper in the mail, so I'm just clearing it up now.
I'll accept your plea to no
I
option.
apologize.
You gotta be more responsible to the judge.
I did put in a change of mailing address with the US Post Office. It just, all the mail came as a clump. So by the time I got it, I missed the court dates. So I've been calling around to coordinate everything now. I have.
To the charge of impeding traffic, responsible or not responsible?
Responsible.
To the charge of no proof of insurance, responsible or not responsible?
Responsible.
So again, I'll accept that plea, accept to no ops, dismiss the suspend, accept the plea to impeding, dismiss the speed, and accept the plea to no proof of insurance. Do you have insurance? You don't have insurance because you don't have a valid license, right?
Correct.
Anything you'd like to tell me?
Whatever the charges are, or am I able to pay it on Monday?
Sure.
That's it.
You gotta stop doing this though.
I promise you I won't do it.
On the no ops, 100 fines, 75 costs, 75 victims' rights fee, $50 justice assessment, 300 or 60 days, 195 on the no proof, and 175 on the impeding. So your total is 495, 595, 670. You can pay all that Monday?
Yeah,
You sure?
I'm positive.
All right, paid by July the 6th, okay? Now, if something happens, you don't have the money, you call the court, we'll go on Zoom, I'll give you an extension. You understand?
Yeah.
You understand you're not gonna ignore me though, right?
I'll come. I will come to you without an issue.
All right, good luck.
Thank you.
Judge,
You're
how much, I'm sorry, Judge, how much was it for the impeding?
The impeding is 175. The no
Right,
proof.
thank you.
Ma'am, don't go anywhere yet. Wait 1 second. That's, and then 195 on the no proof, so that should be 370. What did I tell you had to come with? Come on back up here. What did I tell you had to come? No. Ma'am, come on up here. What did I tell you had to pay?
Is it 490?
No. 175, and it's 495 plus the 175. If I didn't say that, it's $670. Did I tell her something different? No? Okay, so it's 670. Okay?
Okay.
All right, good luck.
Now in hour 3 of TCF Live on a Super Thursday, Dog Mom, $1.99 super chat, says I appreciate this channel. Chat, happy 4th. So Dog Mom, thank you for that. Appreciate it. So you guys have been incredibly generous today, and it is never my position to beg, so I hope it doesn't come across this way. However, I looked and there's an opportunity. We are 5 members away from a 21st custom emoji slot opening up. So here's my challenge. If anybody wants to throw down 5 gifted memberships, the person who does it, as long as it's not inappropriate, gets to choose what that 21st emoji will be. So there you go. It's up to you guys. Let's continue with Judge.
It's a Flat Rock case. I was not able to speak to the Flat Rock city attorney, not in, or at least not in yet. And
Is Flat Rock here today?
No, they are not.
so what I was going to ask the court is to put it off to another date and to allow him out on a personal bond. I know it's been some time, but
3
the
years.
low severity cases, he's done 15 days already in Wayne County Jail and waiting his probation. And I spoke to him about the importance, especially before this court, of coming into court and taking care of his matters.
What's wrong with you, Mr. Bashan? You think you can ignore courts like this?
No, sir.
Well, then why did you?
So I did 7 months and on my probation.
Listen, this is a 2022 case.
Yeah, so.
This is 2026, last I checked on a calendar. It's been 4 years. You didn't show up. No wonder Judge hasn't set that bond.
Yeah, I didn't even realize that I had this.
Realize this now, right?
I don't get it. When is, I'm surprised Flat Rock's not here at all today, Heather?
No.
Aren't they usually here on Thursdays? Is
They
today
are.
Thursday?
He is on vacation.
Oh, okay. Well, when's Flat Rock with me again?
Not till the 14th.
I'll adjourn this to July 14th at 9 o'clock.
We
I
don't
will
have him
give
till
you
the
a-
afternoon that day, Judge.
Oh, at 1 o'clock. I will give you a personal bond, Mr. Bashan, of $3,000. If you do this again, I will make you sit in jail for the longest time until we have a trial. Do we understand one another?
Yes, sir.
Do you understand what date I just gave you?
Yes, sir.
What date did I just give you?
The 14th,
At what time?
1 o'clock.
You still live on, is it Hanover Boulevard?
Yes, sir.
That's where the notice is going. Heather, prepare the paperwork. If you have no other holes, you'll be released.
Okay, thank you, sir.
Thank you, Judge.
Good luck. Thank you. All right. What do I?
Alrighty, lots of love here. Lindsay, you got in first, so you tell me in the chat what you want for a new emoji. But thank you for your 5. Tim, thank you for 5. Barb, thank you for 1. And Tot, thank you for 5. 16 additional memberships today. In case you're not keeping count, that's 83 new people that we have welcomed to the family today. So thank you all for that. And Lindsay, just let me know what you want for the new emoji, and we'll make it happen. Let's go back to Judge Simpson for a few minutes. Let's do that.
Your Honor, I was recently appointed on this case. I'm not aware if I've gotten the rest of the discovery. I've already met with my client. I talked to the prosecutor, gave my consent to sign the protective order so I can get the one video. So if we could get an adjournment for 2 weeks just to make sure I have everything before I set it for exam.
That's correct, Your Honor. I'll have it. Probable cause conference will be adjourned to July 16, 2026, 9 a.m. Bound will continue.
Thank you, Your Honor.
Thanks. Court does call the case People versus Mufud Hisham.
David I. Goldstein is bringing on behalf of the defendant.
Your name?
Mufid Hisham.
What are we doing?
Your Honor, we have discovery in this matter, including the videos. We are prepared to set this matter for an exam.
People have their witnesses available the 14th.
Perfect, Your Honor.
Preliminary examination in person, July 14th, 2026, 9 a.m. before Judge Garwood. Bond will continue. Thank you.
Still. Next week. Look at him. Okay. Thank you, Your Honor.
Thank you. Court calls case People versus Christopher Madison.
Ready, Judge. Court shall feast the first assistant public defender on behalf of Mr. Madison. Mr. Madison, please state your name for the record.
Christopher Jerome Madison.
Thank you.
Thank you, Judge. We did have a conversation with Mr. Madison. He wants to get this matter resolved as quickly as possible. Ms. Dover and I are working on that, asking for a brief adjournment to accomplish that. In the interim period, Mr. Madison working with CMH and headquarter has got him a bed at Bear River. So we'd be asking for release to treatment, Your Honor.
So you just, all right. As to the adjournment, people have any objection?
Yeah.
Do people have any objection to release to treatment inpatient? All right. If it first presented, I will sign that order to that effect. I will adjourn these matters out. Will 2 weeks be enough?
Plenty of time, Judge.
All right. To July 16, 2026, 9 a.m. Bond continue.
Thank you.
Court does call the case of this Phoenix Borns.
Grandma TCF gets in the game with 5 gifted memberships. Thank you, Mom. Appreciate you.
Borns on the one of the matters, Judge. I'll find out which one.
Good morning, Your Honor.
I think
Jackson for Phoenix Borns on the matter ending in 5052.
0709 for the PD, Judge.
Okay, all right. I process of elimination, right?
Yeah, that's right.
Thanks, Lawrence. Thank you. What are we doing? Don't everybody jump in at once.
That's right. On the PD case, the 0709 case, Judge, we'd like to set it for preliminary examination.
Discovery is complete on that one.
To our knowledge, Judge, yeah.
All right. And on yours, Ms. Saxon?
Your Honor, I'm going to ask for an adjournment on this bond violation because of some information I just got last night that I did discuss with the prosecutor, and I'm trying to get an assessment done.
Okay, so if I adjourn yours out, is 2 weeks going to be enough for you to accomplish what you need to accomplish, or you need more time?
I need more time, Your Honor, and if you prefer, I can try track with with the other case.
Well, the other case, they're requesting an exam. But what I'll do on your case is I'll adjourn yours out to July 30th.
Okay.
2026, 9 a.m. All right.
Thank you.
And on the 0709 matter. Would people have their witnesses available the 14th?
We'll do our best, Your Honor.
All right. And in that matter, preliminary examination will be set for July 14th, 2026, 9 a.m. before Judge Washington.
Your Honor, Mr. Barnes would like for us to address bond in this matter. I know that the
Go ahead. He's got a violation in the other case.
Correct.
So
Your Honor,
probably want to make it quick. No, I'll let you talk.
I'll try my best, Judge. Phoenix reports that he is, not engaged in my case specifically. I know that the bond in my case is lower than the violation matter, but I guess this argument could work for both cases, Judge.
Okay.
He's asking that the court consider releasing back on the tether. There's some that Ms. gather from the title of the individual who's worked with him in the past. I think that the information does explain a lot about the decisions that have taken place that has brought him to where he is now. I'm sure he's going to want to get a type of written report to present to court on his behalf. He does have family support. He lives with his mother and his younger siblings. He states that he, based on his interactions with this court, has already enrolled or at least started the enrollment process for school and is slated to start Washtenaw County in the fall. He was working this semester or this summer. He had a lot of plans he had set for this summer, wanted to spend time with his family and his younger brother specifically. Today is his birthday. Today is also the anniversary death of his aunt, who was very, very close to him. He's been doing a lot of work on himself. He reports to me that he's currently in counseling and just been working through a lot of issues or, problems that he has been facing. He is desperately asking that the court consider at least letting him go back home, putting him on home confinement at the house so that he can at least be around his family during this time frame. I do believe that there's an assessment that Ms. Saxon is going to have completed. We have toyed with the idea of something, a little bit more serious, but we'll need to work through those issues.
I don't need a response from the people. Given the violation and the way on the assessment, I'm not going to change his bond until I see something else that would lead the court in a different direction. So motion for bond reduction instead.
Thank you, Judge.
It's TCF Live on a Super Thursday because we're not doing Friday tomorrow. We're taking the day off. Good to have y'all here. Lone Wolf in the chat. Welcome. Good morning to you, my friend. If you haven't checked out Lone Wolf's channel before, go do that. Barbara, be so kind as to drop a link if you would. Let's do this. We got about 40 minutes left. It's time to get a little bit weird with things because that's usually what we do on a Friday. We're not going to go to Dungeon Court yet. And by the way, if you're new to the channel, stick around for Dungeon Court. There's a whole mythology around that place with this channel. But I want to take you to an Arizona court. And Michael Groff, if you're out there, your ears should be perking up. I want to go to the Payson Regional Court, and I want to take you to the Justice Window. And we call it this because it kind of looks like the person is at like a bank teller window or something, the way they have everything set up. So this is from yesterday. It is from the Wayback Machine. We'll spend 10 or 15 minutes there, and you guys can experience Arizona justice. This, my friends, is the Justice Window.
We're here on a criminal damage charge. That is a Class 1 misdemeanor. Did you understand that group advisory information? Yes. Any questions at all?
No.
Okay. Do you have your attorney waiver form with you?
I do.
Did you make a decision on that?
Yes.
Okay. How did you wish to proceed with the attorney decision?
I would like one, please.
Okay. So this case does not have any jail time, so I need you to provide good cause to the court.
Okay.
Do you have any good cause that you can provide? Let's presume you cannot afford one.
Okay.
And then we need a second cause for a court-appointed attorney.
So possibly can't afford one?
Okay, so let's presume that you already qualify on that side. So there's two requirements.
Yes.
Number one, you can't afford it.
Mhm.
And then number two is good cause. An example of that would be if there was jail time, then I could then go into the financial aspect, but there's not jail time on this. Do you have any other cause besides I can't afford one to see if you can get a court appointed?
I don't think so.
Okay, so then you'll back up to the two decisions left, that you waive one or hire one yourself?
Hire one.
Okay, so you want to do that immediately, or do you want to see what the prosecutor says?
Yeah, I'll see what the prosecutor says.
All right, so let me tell you how that works then. So if you, then today, you'll waive the presence of an attorney. That leaves the communication between you and the prosecutor open.
Okay.
Because if you say, I want to hire one today, they cannot talk to you. So then you lose that ability. So you, if you're deciding to waive it now, they can talk to you. You can see if you like what they have to say, and then decide to change your mind and get an attorney, or to proceed forward if they are treating you fairly, if you believe.
Yeah, I would like to have an attorney.
Okay, so you want one right off the bat?
Yeah.
All right, so I'm going to enter a not guilty plea for you, and then you just go hire one.
Got it.
Okay?
Thank you.
I need a different date for attorney day.
Okay. All right, and that attorney waiver form, we can, here, I can take that from you, and we just want, you don't have to fill it out, because you're going to hire one, so
Exactly. Okay.
since nothing's left, we'll save it for the next round. And then what we'll do is get you a court date, and then that'll be, so you go get your attorney. They'll send us what's called a NOA, which is Notice of Appearance, and we're scheduling you for an attorney day.
Okay.
So just remain here a moment. You can answer these questions with yes or no. Is this still a good address for you?
No, I've moved.
Okay, let me get you an address of the day. If you could, simply write your name here and then enter your new information here, please.
Okay.
And if that's a far reach, go ahead and pull it down to you. There
Thank you.
Yep. Thank you. Do you have a phone or email? This will be for attorney communications and court notifications. If you'd go ahead and add that information in there too, please. Thank you. All right. So this is your entry plea of not guilty. A pretrial conference date is set for August 25th of 2026 at 9 a.m. So when you hire an attorney, just make sure they get a copy of this, and then they'll proceed from that. If I could get your signature for that court date here. And I'll get you a copy of this. Do you have any questions at all?
No.
Okay, as soon as we get you a copy, you're all set to go.
Okay.
All right, have a
Thank
good
you.
day. You bet.
Michael Groff, thank you for gifting a membership. Appreciate that. And you tell me, Michael, but I think they've improved the audio at the Justice window. It sounds clearer today. Let me know your thoughts.
I'm going to butcher this. Neda Korganji. Sorry about that pronunciation.
Hello there. How are you?
Okay.
All right, this is case number 2026 CM 12173. Could you state your name?
Neda Kujanji.
Thank you. So this is a charge of shoplifting, a class 1 misdemeanor. Did you understand the information in the group advisory?
Yeah.
Okay. You have your attorney waiver form?
Yes.
Okay. How do you wish to proceed? There's no jail time on the case, so you're not facing consequence of jail.
I want to go
No contest?
no contest. I want to get an attorney because I'm working in assisted living. I'm not working right now because I have a back pain. I have a medical issue, so I'm not working. I'm not allowed. I cannot work right now.
Okay.
But they check me all the time, and if I have any criminal, I have to tell them. I don't want to lie to them because you know.
So this.
I don't know.
So look, we got a lot of it. Hang on one second. So if you plead no contest, there's nothing for your attorney to do. So if you want to plead not guilty, then an attorney attorney can look at the case, because if you plead no contest, then it just gets sentenced.
Yeah, but if they look at the case and I don't know.
Okay. So
Is that possible? Is that possible if I say that? Just give me another chance, just this time.
yeah, so I can't do that at this, the court can't do that now. Okay, so that would be, you'd have to plead not guilty and ask the prosecutor to do that. So you understand that?
Yes.
Yeah, so if you plead not guilty, that means you want to talk to the prosecutor and tell them what's going on and see if they'll give you some kind of plea offer or dismiss it. Court can't do that. Okay, is that what you want to do? Okay.
Yeah, let's do that.
Okay, so we'll do the not guilty plea. Now, if this attorney, do you want to hire an attorney?
I don't have money.
Okay.
Because I'm not working right now.
Okay, so do you want to waive the presence of an attorney then? No attorney?
I want an attorney.
You do want one?
Yes.
Okay, so you have to provide the court, do you want a court-appointed attorney?
Yes.
Okay, so you have to provide the court good cause for that. Let's presume you can't afford it, okay?
Yes.
And then there's a second requirement, you have to give me good cause. One of those reasons is if there would be jail time. There's no jail time, so that cause is gone. Do you have any other cause besides I can't afford it?
I don't have, this has not go to my record.
I understand you don't want it to go on your record, okay? But that's not cause to get a court-appointed attorney. Okay, so do you have any other cause for a court-appointed attorney? You can hire one, or you have to waive the presence.
Yeah, no.
Okay, you don't have a good cause?
I don't have money and I don't have.
Okay, I know, so.
I don't have a good cause.
So let me, okay, you don't have good cause?
Yes.
Okay, all right, so then your options are to hire one or waive the presence of an attorney. Which do you wish to do?
Then I can talk to them personally?
Yes, the prosecutor?
Yeah.
Yes, then you can talk to the prosecutor if you waive an attorney. Is that what you want to do?
Yeah.
Okay, so then check the second box. It says the court has determined that you are not entitled to a court-appointed attorney and you choose not to retain one, correct? You're not going to go hire an attorney?
No.
Okay, so check that second box. And then down below where it says date and defendant, if you would just date and sign that, please.
So now what's going to happen?
I'm going to give you another court date that you'll come back and talk to the prosecutor.
Okay.
Okay?
I cannot do it today.
No, it's a whole nother day.
Okay. Yeah.
If you could answer yes or no, is this address correct here on the
Yes.
complaint? This is a good address?
Yes.
Good phone number?
Yeah.
And a good email?
Yes.
Okay.
Can I ask another
Yes.
question? I don't want to take
Sure.
your time. So if I plan this one today, what is the cost?
Well, I don't know that until I have to, this has a victim related, so we wouldn't know that because we have to get the victim involved. I have to see if there's any restitution. That's why on victim related cases, we have to set a court date out.
So I have to come another court?
You'd have to come back anyway, yeah. But we're doing this one, right?
Yeah.
Okay, that's the one that we're doing, but you would have to come back either way.
Yeah. Okay.
Okay?
So if they
You have the thing?
get me guilty.
I gave you one, didn't I?
No? Oh, I'm sorry, you did. Go
So
ahead.
if they guilty for the next court date, what I have to do?
So if you're going with a not guilty plea, so they're going to do one of a few things. They're going to offer you a plea agreement. They're going to dismiss it. They're going to send it to trial. Or you can change your plea from not guilty to guilty after you talk to them if you wish. Okay? So those are the choices after the next meeting.
After
Okay?
the next.
Yeah. Okay? All right, so here's your next court date, August 10th of 2026 at 9 a.m. If I could get you to sign here for that court date.
I'm sorry, but I have to sign?
Right here where it says defendant. Yes.
Do I have to, oh, it's your copy.
I'm gonna give you a copy here in a minute. I have to sign it too. Sorry about that.
Alrighty, my friends, that is Justice Arizona style. That is the Payson Regional Court Justice window. I hope you all enjoyed. Maybe we'll pay them another visit sometime in the future. All right, it is that time, my friends, where we normally do this on a Friday, but since we're not going to have a Friday, we're going to do it on a Thursday. If you are new to the channel, you are in for a special treat. This is the best, worst court you will ever experience. And as soon as I'm done with my little monologue here, I'm going to drop a link in the chat that is required reading if you are new to this particular court. The blood red carpet ripped straight out of a Stanley Kubrick film. The Cold War era hanging lighting ripped straight from some Soviet war room somewhere. The sandstone wall in the back that if you look closely you can see the blood of the innocent and the guilty seeping from it. The screams from the background. The lights that flicker. The judge that can get really loud and bang a gavel so hard it goes flying and hits people in the head. You've got the crypt keeper for a prosecuting attorney, a printer that never stops running, an overly modulated microphone that somehow picks up everything in this courtroom plus everything for a 2-mile radius. They say Appalachian justice is best served in a cold, dank basement, and they prove that out here. Ladies and gentlemen, with no further ado, I give you Dungeon Court.
Larry Brumfield, 25,658. Is that RRS? It says making progress, so good. Okay. August the 14th will be the next time. 9 o'clock. Okay. All right, good work. You got it.
Thank you, sir.
You're up. Jessica Christian. 19-255, 22-25, 35. She's not here. Still has things left to do. Actually, I have it. Marked down as the 3rd, so let's pass this Monday and see where we are. So, Veronica Howard is here. Case numbers 20-1, 20-2375. And, all right, still have community service and fines to pay.
Yes, Your Honor, I went to pay this morning, but I'll pay before I leave on my fines. 20.
Okay, you gotta get your community service done.
Yes, Your Honor, that's what I wanted to discuss with you. I usually try to get them done, but I haven't been able to do one day. I've had some incidents going on, and I'm having to see some specialists and stuff. So that's why I haven't done a day yet.
Okay.
So.
Well, you can come in, we'll give you light duty.
Do you need to see these papers?
No.
No?
We'll take your word for it.
Okay.
I'll set you for August 17th as your next hearing. See the clerk and make your payment.
Thank you, Your Honor.
You're welcome.
Brian Lively, 25/21/28. Finished the diff school, still has 3 days community service to do and some fines to pay.
Yes, sir.
You have a payment today.
I made it online. I made a $75 payment this morning.
Okay. Let's get your community service done.
Yes, sir.
Okay, August 17th will be the next one. Get it done before then, you don't have to be here.
Yes, sir.
Charles Nance, 25/37, 25/291, 25/331. Service is done for your fines, and you've done extra toward your fines the last period.
Yes, sir.
Good job.
I'm going to work community service tomorrow, but I can give you a payment today too.
Okay, how much are you paying?
20.
Okay, well, we won't probably have community service tomorrow, will we?
Your Honor, he does community service in Athalia.
Okay, all right, well, that'll be fine. Okay, Mondays or Fridays, does it matter which day?
Fridays be fine.
Okay, the 14th of August.
Thanks.
9 o'clock, see the clerk.
And I will be here in the morning if you get some people in.
Okay. Bertha Remy, 26/233. Okay, she was ordered to Bethesda, she's non-compliant.
We were trying her in outpatient first. She just needs to go in.
Okay. Bertha Remy, she hasn't appeared.
I'll try to reach out to her by phone and see if I can get her in here Monday.
All right. She's got 7 days before warrant issues.
All right.
Thank you.
Thank you, Your Honor.
You're welcome.
Brittany Balco, Amber Spears, Bruce Ward, Jamie Welch, Mark Wells, Donald Wilson Jr., Jeffrey Singer.
Brittany Balco is appearing by teleconference.
Your Honor, if I may, I have a note. Ms. Falco was ordered on May 29th to do some community service before the next hearing. She has not been here.
And she made a big payment on her fines. Tell me, where are you? What's going on?
This week, sir.
I'm sorry, repeat that. I couldn't hear you.
I made 2 payments this week.
Okay. What about your community?
I must pause Dungeon Court for just a moment to recognize that the feat has finally been achieved. Julie, a gifted membership. Compliments of who? Your host, the Courtroom Files, who have 10 free gift memberships to give away this month. I gave away all 10 to get it done. Meanwhile, you guys spent $5,284.15 in your attempts. But seriously, your generosity is wonderful. We've got a lot of new members, 94 today to be exact. So lots of new people to welcome in the community, and thank you all so much. And Julie, I'm glad you finally got your gifted membership. Okie dokie, back to Dungeon.
I wasn't able to get it, but I already have someone who's going to take number 28, or number 18, and the 25th of this month.
You're going to be here at the court then?
Yes.
Okay. Where are you now?
Right now, I'm at home.
Which is where?
It's on Norwood in Huntington.
Okay. I'll set your next hearing, and we got you down for coming out for those 2 dates in July.
Okay.
So I'll set you for August the 17th as your next review. So if you get everything finished, the only thing you've got left to do, looks like, is the community service, and you might have $10 left on your fine.
Okay.
Now, you did have to do the driver intervention program. Have you done that? I don't see
I have not set that up yet.
Okay, that's got to get done too. Okay, August 17th, 9 o'clock.
Okay.
Amber Spears, 24-2254. Community service done. Paying on your funds. You made a substantial payment recently.
I'm gonna pay it off tomorrow online.
Okay.
I called Major last week and let him know that I was gonna pay it all off.
And you did do the 3-day school. So I'll give you a date just in case. But
That's fine.
sometimes people tell me they're going to do stuff and they don't. So this will, if you get it done before this date, then you don't have to come back.
Okay.
August 17th, 9 o'clock. Bruce Ward.
Thank you.
You're welcome. Bruce Ward. 11/40/35, 15/268. Bruce Ward. So that's fines left. It's not here, so it'll be bench one right up here. Jamie Welch is here. 21/357 and 18/34/32. And you still have 3 days community service left.
Yes, I was there yesterday.
Okay.
I wasn't here. Yeah, I've got the paper. I brought it in and Major said that I got credit for it.
Okay.
I have a payment also.
How much are you paying?
$30.
Okay. August 17th is your next hearing.
All right, thank you.
9 o'clock. Go to the clerk's office. Mark Wells. 2753/2014, 17/12/73. You're just paying off your fine. You have a payment.
Yeah, 10.
All right. Okay, August 7th, your next meeting.
All right, thanks.
See the clerk. Donald Wilson Jr. '07/27/23. Got a report? Okay. Payment on funds?
I'm gonna pay it off today.
Okay, great.
Anyone has a cell phone on you, turn it to silent or turn it off.
I'll set your next hearing for August 17th, but if you pay it off today, you don't have to be here.
All right, thank you.
See the clerk. Jeffrey Singer.
Yes, sir.
Got a report from Southern Hope for him.
Yes, sir.
And it says you're compliant.
Yes, sir.
Working on getting your driver's license back, so good.
Yep, trying to, yep.
Can you pay anything on your fine?
Not today. I've been paying on it though, but I can't today, Your Honor.
All right, I'll set you for August 17th as your next
All right, thank you, sir.
hearing. Okay, you're doing good. This is the best I've seen you do.
Thank you, sir. Appreciate it.
Okay, that finishes the reviews. We'll start the arraignments next. If you're here for arraignment, your name's going to be called. Come up to the table to your right. Stand there. I'm going to go over the charges with you. You have a right to remain silent. You don't have to say anything. If everything we say in the court is on the record, it's all not only being recorded what you say, but your video of you saying it. So there's a video of you saying whatever it is you say. You have a right to have a lawyer, to have one appointed if you can't afford one, to have bail, and to make the state of Ohio prove any charge against you beyond a reasonable doubt. If you enter guilty or no contest as a plea, you're waiving those rights that I just explained to you. If you don't understand what's happening, if you're confused, if you don't know what to do, you shouldn't enter a guilty or no contest plea. And of course, if you want a trial or a lawyer, you need to enter a not guilty plea when you're asked. Call the first case.
State of Ohio versus Reginald Shearer, case number TRC 26-1084, A and B.
And sir, are you Reginald Shearer?
Yes, sir.
Mr. Shearer, it's alleged that on June 26th of 2026 at 9:58 p.m. in Fayette Township, you were operating a vehicle under the influence of alcohol, drugs, or some combination of those things. It's alleged there's been a prior, but it's more than well, it's got the wrong year on here. Actually, it wouldn't be within the look-back period. So it's alleged to be a second offense. So on a second offense, the maximum penalty, which has increased recently, the maximum penalty now is still 6 months in jail, $1,625 fine, and a 7-year license suspension, so that's increased. The minimum now on a second offense is 10 days in jail, $715 fine, 1-year license suspension, and the vehicle is required to be immobilized for a period of 90 days if it was titled to you. You're also charged with failure to control your vehicle. That's a minor misdemeanor. Maximum penalty is $150 fine. Do you understand these two charges?
Yes, sir.
Do you understand the rights you have as a defendant?
Yes, sir.
How do you plead to this charge?
Not guilty.
Do you want to be considered for a court-appointed lawyer?
I have representation.
Who is your lawyer?
Roger Smith.
Okay. He does practice regularly in this court. He's not here today, so I'll put him down as your lawyer. The not guilty plea is entered for you. I'm going to set your first pretrial for July 27th at 10 o'clock. And you can sign a $2,000 signature bond. You will need to go be fingerprinted at the jail. And there is an automatic license suspension in effect.
Yes, sir.
So the bailiff will bring you a copy of the form you need to take to the jail. You just need to take it down there, ring the buzzer, they'll come and get you, fingerprint you, and then you won't have to say, you'll be released. But you need to do that before the next hearing.
Yes, sir.
Any questions, sir?
No, sir.
July 27th is your next hearing at 10 a.m.
Thank you.
You can leave after you receive the form and take to the jail.
Yes, sir.
State of Ohio versus Joseph Graham, case number CRB 2375.
Dear Joseph Graham,
Yes.
it's alleged, Mr. Graham, that you missed a review hearing
Yes, Your Honor.
back in April 26th of 2024 on our domestic violence
Yes, Your Honor.
conviction. Do you admit or deny you missed that hearing?
I admit.
Do you have an explanation?
I don't. I went down a bad path. I'm just now getting on my feet and just getting back to where I need to be. I planned on making a payment towards my fines later today because I just started a new job and I get paid today.
Okay, so what looks like happened to me, you got arrested on a warrant and then posted a cash bond. Is that
Yes, Your
correct?
Honor.
Are you working now?
I just started a job this week. My buddy, he just got a landscaping business, so I get paid later today.
Okay. Okay, I'm showing that what you have left is $320 in fines and court costs.
Okay, Your Honor. I could pay about half of that later. I could do it via online or come back in.
The other thing I'm showing is, I believe you were ordered to do some treatment. Looks like you went to OVP for a while, but then stopped going.
I completed my in program with OVP, but the outpatient, I did not. You're right, Your Honor.
Okay. Well, I need you to go back there, and I need some updates from them. You can, were you going to the one in Huntington?
I was going to the one right down this road, sir.
Well, that was the inpatient, right?
Yes.
Did you ever go to the outpatient? Because it looked like...
I have not, Your Honor.
Yeah, it looks like that's where you were supposed to follow up with the outpatient center, which is in Huntington on 20th Street. You know where it is?
Yes.
Okay. So I want you to go follow up there. Well, Mr. Min is here from OVP, so I think it'd be a good idea for you all to talk before you leave.
Okay.
And get something set up.
Yes, Your Honor.
Because that's going to be required for you to do. Well, in fact, let's do this. Since it's been a couple years, I want you to do a urine screen today. Let's see what that shows, and then come back and I'll decide what direction we need to go with your sentencing. So we'll recall it after you do your urine screen.
State of Ohio versus Miranda Brandenburg, case number C.R.A. 26369.
Ma'am, are you Miranda Brandenburg?
Yes.
Dale's bringing you a copy of the charge.
Okay.
It's a bad check charge.
Yeah.
States alleging that Union Township on April 17 of this year, you purposely issued a check in the amount of $6,146, knowing that it was improper, was not going to be able to be cashed. That's a felony 5 because of the amount.
Can I
Carries
explain?
maximum penalty of a year in jail, $2,500 fine.
Okay, can I explain something? So I found out yesterday that I had the warrant. I called Chris DeLauder, the lawyer, to get advice. He told me okay, let me explain. So back in April, I worked at Tudor's in Proctorville, Ohio, and they overpaid me like $5,000 and some dollars. So that morning I called them and I said, hey, you overpaid me, by a lot of money. So he came in that day at 10 o'clock and told me that he would take care of it. It'd all be okay and all that.
Now I'm being charged with passing him a bad check. I never even touched a check. Never touched a check, never wrote a check, none of that. So he
Okay,
told me to come
Are
here.
you working, still working? or-
Yeah, I work at McDonald's in Proctorville. I have 5 children. I have no income. I'm already on probation from, sorry, I'm getting upset. But I've been doing really good. Like, I'm amazing. But like, now I'm getting in trouble over something that I didn't do or control. I tried to
Okay,
pay
Let's get you a
him.
lawyer. Who, do you have a lawyer representing?
No, I need a court-appointed lawyer.
But no one's representing you on any other
No,
charges?
everything else is already taken care of.
Okay. I'll appoint Roger Smith. Do we have his card?
When I get nervous, I cry, sorry.
That's fine.
But he told me that I could possibly be put on an OR bond or,
Yeah, I'm gonna give you a signature bond. of
Thank you.
$2,000 signature. And what that means is you're just signing a piece of paper that says, I promise I'll come to court. And if I don't come, I'll have to pay $2,000, but I'm not making you pay anything now.
okay,
Just come to court, you won't have to post any money.
I won't. I mean, yes, I'm here.
So now we need to set a date. What's your work schedule?
I work Monday, Thursday, Friday, Saturday, Sunday. I work,
It's
so,
gonna have to be a Monday or a Friday.
yeah, I can tell, they'll do
Get
it.
off.
I can get it off, yeah.
Okay. Let's do next Friday, a week from tomorrow, so that's the 10th,
The 10th,
July 10th.
okay.
At
Time you
10
sit on a
o'clock,
Friday?
you'll be right back here at 10 o'clock on July 10th.
Okay.
Any questions?
So I'm not, like, I don't have a warrant anymore?
No.
Okay, thank you.
You will, I'm not gonna make her get fingerprint at this point, so we'll worry about that later. Be back here a week from Friday.
Thank you so much.
You're welcome.
State of Ohio versus James.
Alrighty, friends. So, the wonderful thing about Dungeon Court is I can have the volume turned down like 12 decibels and they're still screaming. It's an amazing place. Before we go, Tot recommended that I shout out the other things that we do here, and it's probably a good idea. 94 new members today. A whole bunch of people came through to join us, so a lot of newbies out there. So here's the thing, we have this morning show Monday through Friday, although we're not doing tomorrow, we're taking the day off for the holiday, but normally Monday through Friday, 9 a.m. Eastern, 6 a.m. Pacific. If you are a channel member, you get to join us for the pre-show, which happens a half an hour before this show. Normally that is behind the channel member paywall, but this morning everybody had access to it, so if you'd like to go back and watch that, I had a special message for the 4th of July. Do check that out. Tuesdays and Thursdays, 8 p.m. Eastern, 5 p.m. Pacific, we do Sidebar right here on this channel. That is a brainchild of this community. Our viewers came up with the idea. It's a panel discussion show. We'll take a specific case or a topic or whatever, and we'll banter back and forth on it. It's fun. It's a little crazy sometimes because we have a tendency to get off topic every now and then, but that's good because it's nice to just kind of let loose. And our credo there is we solve nothing, except for that one time when we solved that one thing. But as I recall, I went ahead and privated that episode after so as not to ruin our reputation there. So do check that out. And also In the Blind with Mike and Dan, which is a separate channel. That happens Mondays and Wednesdays. There we go. 7 p.m. Eastern, 4 p.m. Pacific time. So do check that out as well. We've got a lot to offer here. And the big thing that you're not going to find too much out there, although Lone Wolf, if you're still here, you definitely count as being on the good side of this. Almost everything, it seems like in this space, is AI driven now. It's slop created by AI, pieced together, voiced over garbage. We don't do that here. This is human created, human generated, and as you've experienced the chat today, humans interacting with each other. Go figure. So this is where you need to be. Alrighty, friends, we are off tomorrow. Like I said, we will be back on Monday, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. So do join us for the pre-show. We have fun there. The words of wisdom I leave you with today, which seems fitting from Benjamin Franklin, one of the founders of our country. Be at war with your vices, at peace with your neighbors, and let every new year find you a better man. Please do chew on that. Be safe this weekend and enjoy yourselves. I will see you Monday, but oh, by the way, we will not leave you completely high and dry. We will post videos throughout the next 3 days, so you will have content here to watch. Take care. God bless.